matter has become infrastructure, Lordship.
Item number?
Item number 6, Lordship.
Your name?
AB Kayastha.
Council hearing on behalf of public the name with repeated has become public. Second, the petition be closed.
I'm appearing for respondent number 4 in this matter. My name may kindly be recorded.
The government which hears on behalf of the respondent number
4.
4. So taking into account the above, the petition stands closed. As the grievance of
God bless them.
nothing remains.
Lordship, I'd like to mention for listing of the writ petition.
Huh?
Listing of the writ petition, Lordship,
Listing,
for writ petition for day after tomorrow.
you want a writ petition to be listed?
Listing for writ petition, Lordship,
When?
for day after tomorrow. That is
Why?
was filing for yesterday. We filed this.
Motion?
It's
For motion item 12.
May I please? Lordship, here the petitioner, Lordship, to his father, he got a landed property situated at Katagaon, Lordship, by dint of a family settlement deed executed by the father of his petitioner. And as per the family settlement, the name of the petitioner was mutated, Yamamandi was corrected. And since then.
You want a direction that the respondent should not provide a separate electricity connection to the schedule A schematic. Why?
Why, Lordship? Because already there is electricity connection. I have given the consumer number. And Lordship, she was actually, your Lordship will recollect, she is the respondent number 5 is the wife of Virupakha Sharma.
Huh?
Virupakha Sharma, who was a judicial officer, but due to his alcoholic nature, he was terminated. So, Lordship, when my elder brother expired, then I allowed the respondent number 5, who is the wife of the deceased brother-in-law, as a permissive occupier to occupy rooms, Lordship, in the RCC building. Thereafter, what she did, Your Honor, Lordship, my name was mutated over the entire land and building in 2005. 2005. And when I allowed the respondent number 5 to use as a occupant, permissive occupier, Lordship, she committed fraud, and in a fraudulent manner, without giving any notice, she mutated, along with her 2 daughters, mutated her name over the landlordship. And thereafter, Lordship, recently she applied for electrical connection, Lordship. Already that house is where the respondent number 5 is living, it is having electricity, and we are not going to disconnect in any manner. That undertaking I am ready to give, Your Lordship. No, she will not be disturbed. But fraudulently, she, Lordship, mutated her name. Then fraudulently, without having my consent, she applied for taking the electrical connection. And as per the supply code, Lordship, without having the consent of the actual owner, Lordship, the connection cannot be released. And as per the supply code, Lordship, in a single building, Lordship, 2 connections cannot be provided, Lordship. That, Lordship, is the supply code. Supply code clause is 3.10.2, Your Lord. Consent of the actual owner must be obtained.
But their names are there.
Where, Lordship?
Their land is also mutated in their
Yes,
name.
yes, I have already submitted fraudulently.
So,
she
but whether it has been done fraudulently or not, that is the subject matter of the.
yes, of course.
So therefore, as of now, he is the owner.
No, of course, Lordship, fraudulent, there is a Supreme Court decision, Lordship, that if a fraudulently anything was done, Lordship, in that event.
A fraudulent anything is to done, it will be void later on. But first it has to be fraud. You know, prove it.
Lordship, he is not the owner of the property, Lordship. Property already stands in the name of the petitioner, Lordship. And Lordship, I'll file a civil suit for the cancellation of the name, Lordship. Only I may be protected for 15 days, Lord.
Why?
Because
What
if
is
the
this protection?
electricity,
We are concerned with the judgment of belief that where electricity is an essential. Why
Yes,
should
yes,
we?
I know
leave
that
this
judgment.
Lady,
I am
at
having
your
the-
mercy.
I have gone through that judgment. I am having the copy of the
It's
judgment also.
we can't
But-
leave it at your mercy.
No,
Whether
Lordship,
you give or not, let them, APTCL take a fall. They know what to do.
no, Lordship,
I am not going to
as per
interfere
the
in this
supply
type of
code,
thing.
Lordship,
Clearly, Nothing doing. This type of cases are to be.
Lordship supply, there is a judgment also, Lordship, that everything will be guided by the supply code, Lordship. And the clause number 3, Lordship, 3.10.2.
What do you want? Go to the civil court, get an injunction there, not here.
Lordship, that,
I am
give
not here.
give me 10 days
Here
time.
is a case for dismissal right away.
Give me 10 days time,
Not
Lordship.
even a case of notice. Notice is, did I issue a notice in this type of case?
Lordship, I came to know,
Notice is also bad. Notice is not, you are not entitled even to a notice. Notice is too big a thing which will help you. Division bench may help you. But I am not going.
no, Lordship, I pray only for 10 days time. I will be protected.
Praying for what?
I'll file suit for filing suit.
Who you filed? Or you just change the nomenclature of this. Instead of Guwahati High Court, put it before the court of the civil judge, senior division number 1. Or before the junior division number 1. That's all. Remaining remains everything. Do it.
Lordship is fully aware regarding,
I'm not going to do this.
no, Lordship is fully aware regarding the law of the
That's
permissive
no video.
occupier.
My goodness. Okay.
Only for 10 days I may be protected.
That should be not issuing a notice. You first, I'm not satisfied of issuing a notice. What about protection? Yes.
Then I may be allowed to draw.
Mr. S.P. Roy, the learned counsel, appearing on behalf of the petitioner, submits that he,
Would be on the ground that I'll file suit.
that is your look. Submits that he would not like to press the instant petition, taking into account the dispute pertains to a dispute of civil nature. Submits the KP Pathak, appears on behalf of the petitioner, taking into account the above the circumstances.
For admission, item 1.
Yes, what is this?
May is a lordship. My lord, so far as the respondent employees are concerned, they take a plea before the learned tribunal that they were retrenched. But the management has taken a plea that no, they had resigned. Now, both the pleas were considered by the learned tribunal and the award at page 40. Only 2 paragraphs might be relevant. At paragraph 48, page 26.
Paragraph?
48, page 48, paragraph 26. This is where the learned tribunal is in their favor. May I read, my lord? From the evidence of all the above workmen witnesses, it is found that the management has retrenched them from their service on 2/1/21 without giving any prior notice. But to prove the fact, none of the witnesses have produced any relevant document. Retrenchment from service is an order passed by the management, and before the issuance of notice is must. So, but no such document has been proved. Now, paragraph 33 on the next page, 49. On the aspect of resignation, my lord. Say to that extent the management is true, but before taking voluntary retirement, anyone is to inform to the management by way of application or letter so that the date and time can be calculated for giving the legal dues, but the management has also failed to prove that the workmen themselves took voluntary retirement. Now, last part, 35. The crux of the issue is that whether retrenchment is justified or not. So as per the discussion held above, neither parties have proved their respective plea. That is the plea of retrenchment that they took by the workmen and voluntary retirement by the management. Ultimately, what is there, at paragraph 39, 40, 39. Since the management has not denied the workman as their employee, hence it is directed that the management to continue services of the workman with effect from 2/1/21 by giving usual pay and allowance as admissible under the so-and-so court judgment. And my lordships, I'm on 2 points, my lord. The first one is, so far as the issue framed at page 41 is only in context with retrenchment. It is not in context with whether retrenchment or resignation. Subsequently, when the award
I've
was-
not read the file.
My
but
lord.
What I can gather from what you have stated on the paragraphs I've read,
My lord.
it appears that these persons concerned were retrenched within the meaning of section, what is that?
2O,
2O,
00,
2O,
200.
2W. Without following the mandate under 25F. And as such, the challenge was made, it led to an industrial dispute.
Right.
Your case is that they have voluntarily retired, submitted the resignation, and as such, where is the question of
Retrenchment.
retrenchment?
Right.
That's your.
Both could not prove their case by
So
document.
the moment they could not prove,
My lord.
the duty is upon you to prove that you have terminated their services by following 25F. Matter and,
We were not on 25F. We said they left.
huh?
We said they left.
Have you proved voluntary?
No, we did not
resignation?
prove anything. They could not also prove
It's
anything.
not, they are not required to prove. You admit that they are the workmen.
Page 31.
They were working under you is not in dispute.
No, not in dispute.
Now you say that they are no longer in service on the ground that they have submitted the voluntary resignation.
My lord.
You could not prove that.
Yes,
That is a finding of fact.
that's fine.
So if you could not prove it, now what is the next course of action? Whether they prove retrenchment or not, they are not required to prove anything. They continue to be workmen unless you take steps under 29, 25F.
F.
That's it.
With notice. No, my lord,
Why do you need the file
page
to dismiss
31.
your case? Matter
Page
over.
31. They stand, page 31, their prayer before the authority, before the tribunal. Their prayer. They are not paying for service. It's only pecuniary prayer.
Mr. Banik, kindly don't change the perception of this court in respect to the labor court matter. The labor court is to decide on the basis of the reference,
Correct.
not on the basis of what prayer it is. The reference categorically says that as to whether this person were terminated. This is what we find in the first, whether the person so and so are justified in retrenchment of 8 numbers of as mentioned.
I get the point.
That's it.
I get the
Matter over. You have not proved it. You have not, for doing so, you have to follow issuance of notice as per 2W. No. Matter over. Why? Better do something. What do you want now?
Although they
Dismiss.
they were actually
In the
paying for,
morning, today, bad
No, no.
motion has
they
withdrawn.
were also paying
I
for
hope
pecuniary
it's
relief. my
not
lord.
been withdrawn here also.
Whereas page 31, they were actually paying for pecuniary relief. That's
Huh?
what I'm on. They were also paying for, they were not for reinstatement, rather. Their prayer may be seen once. If we can work out on that. Whatever to be reached,
Page
31. They are not paying for reinstatement as well also. This is stamp they have now. And some payments have been made to them. Page 28, I believe.
setting aside the quashing of the retrenchment, issue a directors to so and so to pay to the retrenched employees all consequential benefits which they are otherwise entitled. In the alternative, may be pleased to direct the management of year to pay it under which they are entitled, including payment of the 3 months salary in lieu of notice and so and so. Payment of appropriate compensation to 8 retrenched in accordance with law. It is in the alternative.
They are on two minds open whether they would like to go for a mediation on this point. That I'm on that. If they have an alternative, because at this position, again reinstating all where the vacancies are there.
Why?
Of course, I get the point. If I could not prove this part, the second part had to be.
Retrenchment by following the due process. That's how you do it. You can't do it by judgment. What to do it, do it. What to do? Dismiss. The stay also.
Still, yeah.
But this stay, have you got the last waited?
No, you're lost.
Yes. I'll turn waited also. You.
They've been given some things at page 28, what we have indicated.
Huh? What? Oh, luckily, it has not been stayed for long.
No,
Not for long.
Dismiss, withdraw.
on the withdrawal may not put it be day after tomorrow. I need, as a lawyer, that instruction to come, it will be very easier for me, convenient rather. For me to say it will be long.
2 o'clock. Not day after tomorrow, 2 o'clock.
Obliged.
Because I have time then to decide. Day after tomorrow would be, day after tomorrow would be 14. There are more many.
Lodge.
Or 2 o'clock we finish.
Item 3.
Workman, oh, here he is not represented. To do. Okay, none appears on behalf of the parties on call. The court, for the ends of justice, adjourns the matter to be listed on 14th of August 2025. Oh, no, not 14th, 21st of August 2025. It is observed that if the parties are not present at this court, we can file appropriate office.
Item 4.
May please your lordship, this matter may kindly pass off for the today because as Chakravarti sir out of station.
Who?
As Chakravarti sir out of station.
2016 matter, does it? That too, these people have already suffered a judgment being not delivered after hearing. Hearing was going on.
Hearing was completed, written arguments were also were submitted.
What is your case?
My lord, in fact, the issue is, my lord, whether the management can, my lord, for the first time adduce additional evidence before the labor court after the workman was terminated without holding an inquiry.
Huh?
After workman was terminated without holding an inquiry. In fact, what happened? The show cause notices are issued asking the workman to submit reply within 24 hours. He submitted within 24 hours and soon thereafter it was terminated. No inquiry whatsoever. Now, my lord, the matter then went to the conciliation first and then the labor court. Labor court, my lord, in the labor court, I submitted a written statement taking specific plea that there was no inquiry whatsoever. Now, my lord, the management filed the written statement, did not take the plea that they, you know, in respect of there was he said they admitted the charges, so no inquiry was required. Now, I knew that the management did not want to adduce any evidence to prove the charges. And then I adduced my evidence. Thereafter, the management submitted list of 14 witnesses, asking for issuing summons to 10 number of witnesses. This I objected because the Supreme Court has held, my lord, if you want to, number of decision in the larger, it went to the larger bench also. They said, if you want to adduce evidence for to prove the charges, you must at the first instance say in a written statement that in the event that the tribunal finds or level court finds that there is no inquiry, they should be given the opportunity to adduce evidence to prove the charges. If that is not there, then they cannot at a later stage ask the tribunal to adduce evidence. That is what is there. Now, tribunal, the level court will not rejected my prayer, and against that we have come. But the Supreme Court, I have given a
You have
judgment.
come against the interim order.
Interim order means
It's
because
interlocutory order.
interlocutory order because
And
they,
it has been pending from 2016.
that is why. Well, in fact, it should have been,
This, you could have very well gone ahead and have the matter done and then come up before this court.
well,
Not
I
that.
have been trying, but then in any
You
case.
can't do that.
Hmm.
These are bad. For last 9 years, you can't.
That's right, that's right. So your lordship, my lord, because this.
There are judgments, many judgments of the Supreme Court also. The question of interference at these interim stages does not arise.
In any case, my lord, since the court has passed an order, so lordship will, your lordship will have this judgment, my lord, Supreme Court, I hand up to your lord. This is a full, I mean, larger than judgment, my lord, Karnataka. Supreme Court has clarified it, my lord, after looking into this. My lord, it says lordship Karnataka pay, lordship will find that pay, paragraph 3. Supreme Court larger bench has upheld the judgment of the Shambhunath Goyal case. Paragraph 3, my lord, see, the rights which the employer has to law.
You have already given copy. to-
Lordship, I'm sorry. my lord.
You are referring to Karnataka.
That's
state.
right, my lord. This is the judgment, the larger bench, it was referred to the larger bench.
Which paragraph?
Para 3, my lord.
Right of the employer.
And this was upheld by the Supreme. My lord. And in para 15.
But how will this apply when there is no domestic inquiry?
No, that's why, because this, they did not, in so many words, said there was no inquiry. Says there
No,
was opportunity.
normally a domestic inquiry is envisaged.
That's right.
Then what happens when a domestic inquiry is being envisaged on the basis of the domestic inquiry, show cause notices are being issued. And then the termination happens. Normal. Thereupon a dispute happens and this dispute goes to the being referred. Now, initially, you may very well take up the plea as regards the fairness of the inquiry as a preliminary issue to be first decided
I
in
have
your
taken-
written statement.
Lord,
When you do that, when you take the decision, immediately thereupon, in that written statement, you also mention that in the circumstance that it is decided against us.
well, in fact, this plea is to be taken by the management.
Yes, if
Not-
it is
not-
decided against us, we take. But when there is no
That's-
domestic inquiry, because you see, the reason why it is so, in the initial stage, whenever that particular, you have already adduced the evidence before the domestic inquiry. And in the domestic inquiry, on the basis of that, the report is being submitted, inquiry report is being submitted. So there is already evidence. Once the fairness is being upheld, then nothing remains.
Lord,
So in the first stage, prior to adducing evidence, prior to deciding the preliminary issue on the fairness of the inquiry, you adduce only evidence by the management only limited to the fairness.
right, exactly. Lord.
And thereupon, what happens at that point of time, you take the plea. But when there is no domestic inquiry, where is the question arises?
It happened like that. The management did not say there is no, because it is the management who is to take. I said there is no domestic inquiry.
Understood. They also never, it is not a denied factor or it is not denied to the effect that there was a domestic inquiry.
No,
Here he says that this person, as I could gather from what you are stating, they say that look here, when we issued the show cause notice, they have duly accepted it. And
No.
as such, there was no necessity
no,
of him.
they also say all opportunities were given to him.
Understood. But
So-
then they say that, look here, all opportunities were given, but they never said that they had a domestic inquiry.
No, did not say, but in fact, they did not say, but since they said that opportunities were given, tribunal went ahead, labor court went ahead. Therefore, I had to adduce my evidence. I have taken specifically.
That this judgment which you are referring to is pertaining to more particularly in respect of. Now let us see what was the judgment Justice Patel. Patel, what was he saying? Justice Patel was for Justice Khare and himself. There are three.
Three judgments, one conquering, one dissenting, my lord, but then ultimately Justice Patil said that it is the labor court's power to
They wrote it for himself
lordship.
and Justice Barucha. And there it was, the right which the employer has in law to use additional evidence in a proceeding tribunal or industrial tribunal under so and so.
They have to
questioning
say
the legality and order of terminating must be availed of by the employer by making a proper request at the time when he files its statement of claim or written
And now they want, my lord.
written statement or makes an application seeking either permission to take certain action or seek approval of the action taken. This decision was rendered by this court by while deciding the so and so it can go to its court. Considers whether we find that
It relied on the earlier judgment, my lord.
Before we proceed to examine this document, not what the good thing is for the when a domain has been held by the management and the management relies on it, the management may request the tribunal to try the validity of the domestic inquiry,
Yes,
preliminary issue, and also ask for an opportunity to
That's-
use evidence before the tribunal if the finding on the preliminary issue is against the management.
that's right, exactly. my lord.
In such a case, if the finding on the preliminary issue is against the management, the
Then-
tribunal will give the employer an additional opportunity.
Right.
So this is what I understand.
Yes, exactly.
The words before the proceedings are give rise to the above with the case of. Which I wrote the case of Sampuna, the propriety of waiting in the preliminary issue was decided to give an opportunity because after the decision made on the validity of either way, there was nothing much left to be decided. Therefore, in Sampuna, this court once again considered the question of the different perspective. Right. But if How many judgments, how many judges were in Firestone?
Firestone, my lord, this was discussed here, Firestone, my lord.
Firestone was only discussed by Justice Sabarwa.
Yes. Firestone is, my lord,
How many judges were there?
Firestone.
You are appealing for whom?
As security, as security,
In fact,
as security.
it happened like that. There were earlier counsel, my lord. After that, my lord, the honorable court appointed a secretary as amicus.
Am I?
Amicus.
And he is out of station and
Who?
in S. Chakraborty.
He's saying-
Suman
Suman
Chakraborty.
Chakraborty, sir.
Not necessary. We don't need amicus. I will be the amicus. Don't worry.
Firestone was discussed in this judgment.
And Firestone was only discussed by Justice Sabarwa in the
Yes.
dissenting.
Dissenting, my lord.
Yeah, only in the dissent.
My lord, it was two judges, my lord. Two judges, my lord. First.
Now here the learned labor court allowed it.
Yes.
Now, what do you say about the opinion rendered by Justice Shivraj Patel?
At the end, my lord,
And so that the power is still there.
that is the court's power.
Yeah, the
That-
court
that-
permitted.
No, after evidence, because my lord, yes.
Now, first of all, this judgment would not apply in your case.
Because
But
then,
secondly, when it has been already given, when the court has already exercised the power, why should this court interfere? More particularly in view of the later part
What
where
I-
he has added, because this is
my
also where
my prayer before the tribunal labor court was, the management did not want preliminary issue. If the court holds that it was an inquiry duly held, I have nothing to say. If the court, after framing preliminary issue, finds that there is no inquiry, then the management they can. That is a different matter, bro. Now but for that they'll have to ask for it at the very initial stage, because I know that they will not adduce evidence. I know that they will not adduce additional evidence, therefore I adduce my evidence. If I would have known that they will adduce evidence, then my evidence would have been different, because I will be prepared with more evidence, more witnesses. Because I know that this is what the Supreme Court has held, and Shankar Chakraborty specifically said, the tribunal has no duty to ask the management to adduce evidence. And it is
but
not
that
Shankar Chakraborty.
Shankar Chakraborty's judgment did not take into account Cooper.
That is why
That is why.
that is why.
That is why the Cooper was not looked into by that Shankar Chakraborty.
But Shambhu came into being, but Shambhu was
Shambhu was there. Shambhu is also the larger, it was the three judges.
yes, Shambhu and
Shambhu also, the majority did not look into the Cooper.
no, my lord, Shambhu, they did not look into that was in my lord, the other judgment. It was Shambhu Goel, and that was the other judgment was, my lord, Rajendra Jha. Rajendra Jha that did not look into. Rajendra Jha also did not, my lord, disagree with Shambhu as such. No, my lord.
No, if we have to go
if-
by the constitution, the
if-
power is still there. The court may
No,
very
no.
well ask.
That your lordship will see. He said it
I
is.
think we finish it. No. This matter should not have, first of all, been admitted at all. Notice should not have been issued.
No, my lord.
We've done all this matter there.
Then my lord,
Once
what will
it
happen?
will-
Because your lordship will, I'll be seriously prejudiced now if they want to prove the charges now. They
Well-
held no inquiry.
Huh?
They held no inquiry and terminated within 24-hour notice.
So,
And then if they want to, because I have adduced my evidence,
so
now.
you adduce, you want to adduce further evidence, do it.
No, my lord.
You
how
see,
can-
another thing about the Shankar Chakraborty as well as in Shambhunath, another very important thing. Did you, who files the written statement first?
I filed my written statement.
In the written statement, you have said that you are going to adduce evidence.
No, I written statement, I said that there was no inquiry and the termination was, my lord, order was passed without holding inquiry, giving me an opportunity whatsoever. After
What is
that,
this prayer for framing of a preliminary issue and disposing of the case from preliminary issue? What is it?
that is my prayer.
You asked.
I asked because they didn't ask. I asked because I had to. Said, you please see. I asked because they didn't ask.
Statement has filed the evidence of 13 witnesses. These 13 have adduced evidence before this court. 6 is both of the both of the order of the petition. Then when not serious, related.
That is contrary to section 11A.
Thereby your petition. Where is that order by which the court permitted?
My lord, the page 84. Court did not exercise its own power.
On Toronto, the learned counsel has filed a petition saying to paper preliminary inquest whether the inquiry adopted by the India before the termination was fair. It can obtain. Workman side filed application number and public where late petition move the process of the same and the So, one of the applicant has already been examined, means you have been already examined early. And he was prosecuted and discharged by the court, and this court was pleased to fix the evidence of the, let's see the records, I taken. I'm only making the foundational facts for my judgment to dismiss your petition. Otherwise,
My lord will also have a look at section 11A of the Indus. The lordship is aware of that. Proviso to section 11A. I think, my lord, this should have been settled at the mediation.
2016. Both sides filed Hazira. W1 is present for being cross-examined and accordingly he is so cross-examined and discharged. Heard. Workman's side evidence closed as desired. So and so for filing evidence on affidavit by the manager. So the court exercises this power, not on an
That is-
application.
That is, my lord, if the court
No.
finds
Here the
that.
court
No,
exercises the jurisdiction.
no, why the court will exercise, my lord? The court has no power to ask the management to, because court will exercise power only when it is required. The evidence is insufficient. Or in order to ascertain the fact, my lord, court of its own will not automatically exercise the power, my lord, as a matter of course.
You are challenging the order dated 27/5/7/2016.
My lord,
Isn't it?
the order dated,
25/7/2016.
that's right. Let them adduce evidence whatever they have during while passing the order. Lordship will have a look at section captain, Lordship is aware of it. No fresh evidence, that is what the statute says.
That judgment of Karnataka would not apply. Heard Mr. P.K. Roy, the learned counsel, appearing on behalf of the petitioner. Which- The legality and validity of the order dated of the order dated 25/7/2016 passed by the learned labor court, Kamrup Metro, Guwahati, in reference case number 23 of 2015 have been put to challenge by way of the present writ petition. Next. The issue which is involved, issue which have been raised in the instant proceeding is as to whether the respondent herein, respondent number 2 herein would have been permitted to adduce evidence when the respondent number 2 did not take a plea in the written statement. That's the issue.
Additional evidence.
There is no evidence at all. Where is the question of addition?
No, for additional evidence, whatever evidence they had, when.
No, there's no, has to be evidence.
Right.
Where is the question of additional evidence? For understanding, for appreciating the issue, for the purpose of adjudication of the above noted issue, which is being raised in the present petition, this court finds it pertinent briefly to take note of the facts which led to the filing of the instant petition. The petitioner herein was appointed as a sub-editor in newspaper weekly. Assambani is what? Bi-monthly. Assambani is by 15 days, na? Assambani used to be 15 days. Nowadays, I don't think we have Assambani.
I have not seen it.
Somebody with something like 15 days. In the newspaper, the Assambani, which was a unit of the Assam Tribune group of newspapers, with effect from 1/1/1987, on the basis of an order issued on 22/1/1987. On 4/6/2014, a show cause notice was issued by the editor of Assam Bunny, alleging that the petitioner was not found available during the official duty hours from 31/5/2014 to 3/6/2014 after signing the attendance register. The petitioner claims that he had submitted his reply on 7/6/2014, stating that he was very much present on those days and did his assigned job. Subsequent thereto, another show cause notice was issued. It is the further case of the petitioner that on 5/6/2014, another show cause notice was issued. Alleging that the petitioner had submitted an article titled, inverted comma, Public Interest Journalism and Violin Syndrome, inverted comma, close, in the souvenir book, inverted comma, open, Role of Media in Serving the Public Interest, inverted comma, close, and released by the Press Council of India on the National Press Day, dated 16/11/2013, wherein the petitioner had given his designation as editor Asambhav Bani, which according to the management was falsification of facts and misleading the public. The petitioner was given 24 hours time to submit reply to the said show cause notice. The petitioner further claims that he had hurriedly submitted a reply on 7/6/2014, stating inter alia that he had only submitted the article through email with his name and he was not aware about the designation as published in the souvenir, and perhaps the Press Council of India themselves put the designation as editor. Petitioner further state that prior to the two show cause notices dated 4/6/2024, 14 and 5/6/2014, another show cause notice was issued on 27/5/2014. Alleging that one Srimati Inakti Soitia Borua had submitted a written complaint that a petitioner who was the president of the Assam Journalist Union had used her name in the list of members of the Journalist Union of Assam for procuring a liquor license from the Excise Department. The petitioner was directed to file the reply, which the petitioner claims to have submitted a reply on 28/5/2014, denying and disputing the said allegations. It is further seen that the petitioner was also issued another show cause notice on 2/6/2014, alleging that the management of the respondent number 2 possessed documented proof that the petitioner had written a series of editorial articles in the editorial page of Doinik Agrodut, which inverted comma Pratyasha Aru Akhanka ASHANK inverted comma dated 19/5/2014, comma Radia tapes inverted comma RADIY tapes dated 30/4/2014 and Grismonda GRISMADH dated 28/4/2014 without according to the management, which was unethical profession, etc. The petitioner submitted a reply on 3/6/2014 state denying that he had authored such documents. It is the further case of the petitioner that the managing director of Assam Tribune and the Assam Tribune, managing director Assam Boni and the Assam Tribune group thereafter, without following the manner and the procedure laid down in the standing orders, and in gross violation of the principles of natural justice, terminated the services of the petitioner without holding any domestic inquiry by issuing an order dated 19/6/2014. The record further revealed that that pursuant to the said termination of the petitioner on 19/6/2014, a conciliation proceedings was initiated by the Assistant Labor Commissioner cum Conciliation Officer, Kamrup Metro. However, the said conciliation proceedings did not reach the desired result for which a failure report was submitted.
Failure report was not submitted.
Huh?
Before that,
Did not desire the did not reach the desired result. Which led the petitioner to approach the learned Labour Court Kamrup Metro Guwahati for redressal under the Industrial Disputes Act 1947 as amended by the Amending Act of 2010. So you moved directly.
No.
There was no reference made here. No? Now tell me, how are you a workman?
I'm working, workman.
How?
They have not said, but I'm
No, that is okay, but I am asking, how are you a workman? Sub-editor of a newspaper, how can you be a workman?
that can be, decided by, if I'm not working, that can be decided by the labor court.
I mean, this is a very difficult way. How you are covered by the working journalist, all these things.
There is a standing order.
Huh.
Standing order act says workmen standing under the standing order.
It will be governed by the standing orders applicable to working journalists. So working journalists have a different thing. They would not come within the Industrial Disputes Act.
But a standing journal that is certified by the under the industrial dispute.
Maybe,
standing.
but would he come under the concept of a workman?
But under the standing order, the term workman means workman as defined under the Industrial Dispute Act.
In the?
In the Industrial Dispute Act. Standing Order Act says the term workman means as the workman as defined in the Industrial Dispute.
No, understood, but how can a sub-editor be a He cannot be a workman.
Workman dismissal, industry.
Do you have a
I'm not a
different-
managerial post, it's not a managerial post.
May not be, but you come under there is a different tribunal for that. Working, the provisions of the industrial as in force for the time being shall be subject to modifications specified in one shall apply to or in relation to working as they apply to or in relation to workmen. So here what they have done is by working journalists would not be a workman. They would not be a workman, but what happens is by legislature, by incorporation, the provisions of the Industrial
That's
Disputes Act have been dropped. That is
Exactly.
Section 3 of the Working Journalists and Other Newspaper Employees Conditions of Service and Miscellaneous Provisions Act 1955. And the provisions of the Industrial Disputes Act 1947, as is in force from the time being, shall subject to modifications specified in subsection 2, apply to or in relation to working journalists as they apply to workmen. So by legislature, by incorporation, it is. So you are not a workman, but you are a working journalist.
But then I come within the industrial dispute.
No, you don't. You come under this act. The Working Journalists and Other Newspaper Employees Conditions of Service and Miscellaneous Provision. You come under this act. But what has happened by this act, the working journalists who are there, they have been given the same benefits which are given to workmen in the industrial disputes.
And
This
there-
is what is being mentioned in section 3. Shall apply to or in relation to working journalists as they apply to or in relation to workmen within the meaning of that act.
Therefore, as I understand, my lord,
Section except 25(2) does not apply. Section 25(2) of the said act in its application to working journalists shall be construed as if in clause A thereof for the period of notice referred to in relation to retrenchment of a workman, the following period of notice in relation to of the workman have been substituted. 6 months in the case of editor and 3 months in the case of any other working year. So this is how it is. In respect to cases we are. Anytime from Iman to Iman, any working year has been retrenched, he shall be entitled to receive the employer from the employer wages of 1 month at the rate of which to payment of gratuity. Termination of the work. If you- Show me the Assam, yeah, Assam industrial dispute rule, with the rule made. So here it is not a case of a reference being made.
No. So I can directly go, my lord, after 45 days. if there is the conciliation of it does not take any further action, after 45 days I can go. Because it is a termination in view of the amendment, my lord.
But 11A will only come into when there is a reference being made.
It's deemed to be reference, it is deemed reference. my lord.
Huh?
Section 2(8) says it is deemed to be reference. Section 2,
No, kindly see, where an industrial relating to discharge of dismissal of have been referred to a labor court tribunal layman for adjudication. And in course of the adjudication, the labor court, as the case may be, satisfies that the order of AI dismissal is not justified. Then
right.
you're referring to section?
Section
An
2,
employee discharges expenses so and so.
2 says, 2 capital A says,
No, it is a deemed to be a dismiss, industrial dispute.
under section 10.
It is deemed to be an industrial dispute.
Under section 10.
Notwithstanding anything contained in section 10, any workman as specified may make an application directly to the labor court or so or referred to therein, and after the expiry of 48 hours that he has made the application to the compensation for shall have the power and jurisdiction to adjudicate of the dispute as if were dispute referred to it by the appropriate body with the provisions of the act, and all the provisions of this act shall apply. This meaning, are you submitting that in a proceedings of reference, there can be no evidence adduced?
I'm not saying that. Evidence, it is a matter, but evidence can be alluded, it is the rules it provides, the parties.
No.
But
See.
in case of dismissal, termination without holding an inquiry, it is the duty of the management to, at the very first instance, take this plea, alternative plea. In the event after deciding a preliminary issue finds,
Okay, look. Illegally. Had approached the learned labor court. For redressal under the Industrial Disputes Act as amended, as per the amending act of 2010. At this stage, it is very pertinent to observe that the petitioner herein is a working generalist. And as such, the provisions of the working journalist and other newspaper employees bracket conditions of service bracket close and miscellaneous provisions act 1955. For short, the act of 1955 would be applicable. Pertinent herein to observe that in terms of section 3 of the act of 1955, the provisions of the Industrial Disputes Act 1947, for short, the Act of 1947, have been legislatively incorporated to the provisions of the Act of 1955. And the said provisions of the Act of 1947 shall apply to and in relation to working journalists as they apply to or in relation to workmen within the meaning of the Act of 1947. The record reveals the records of the records of reference case number 3/2015, which were called for by this court, have been perused. A perusal of the said records revealed that the petitioner had filed the application under section 2A of the Industrial Disputes Act 1947 and by an order dated 23/3/2015, notices were issued to file written statements, if any. The respondent number 2 thereupon appeared and filed written statement on 1/6/2015. And the petitioner herein was granted the opportunity to file additional written statement. The records were to reveal that the learned petitioner, the parties were thereupon directed to file additional written statement. On 14/7/2015, the management filed their additional written statement. However, the petitioner did not file the additional written statement. We filed. Additional, did you file? When? The file, talk for time. And the petitioner filed the additional written statement on 3/8/2015. On 6/10/2015, issues were framed by the learned labor court. The issues which were framed were, inverted comma, number 1, whether the management of Assam Bani and Assam Tribune Group was justified in terminating the service of Sri Gitartha Pathak, assistant editor of Assam Bani by virtue of the order dated 19/6/2014. Question mark. Number 2, whether Sri Gitartha Pathak is entitled to reinstatement in his service or to any other relief in lieu thereof. Question. After filing of the said written, after framing of the above issue, comma, the learned labor court provided opportunity to the petitioner to adduce evidence. The petitioner adduced his evidence by filing the examination in chief on 15/12/2015. And the cross-examination of the petitioner was concluded on 19/4/2016. This court finds it very pertinent at this stage to take note of the order passed on 19/4/2016 by the Learned Labour Court. Both sides filed Hazira. Full stop. WW1 is present for being cross-examined, and accordingly he is so cross-examined and discharged. Dot. Heard. Dot. Workman side evidence closed as desired. Dot. Fix 6/5/16. 6.5.16 for filing evidence on affidavit by the management. The record further reveals that the management, on behalf of the management, evidence on affidavit, examination in chief on affidavit were filed of two witnesses on 23/5/2016. And of one witness on 23/5/2016. And on 7/6/2016, filed evidence examination in chief of twelve other witnesses. And further prayed for adducing further evidence, which prayer was allowed. Thereby fixing 18/6/2016 for cross-examination of management witness number 1 to management witness number 13, and further evidence and hearing on petition number 369/16. It is very pertinent to mention that the petition number 369/16 is a petition filed by the respondent number 2 for calling for witnesses, for summoning of witnesses. And this application was allowed. Itu na like 369. On 18/6/2016, On 5/7/2016, on 5/7/2016, the examination in chief of the management witness number 14 was filed. On behalf of the workmen, a petition bearing number 443/2016 was filed for framing of preliminary issue. And the learned Labor Court fixed 12/7/2016 for direction, objection, and objection hearing on petition number 443/2016. Objections were duly filed by the respondent number 2. It is also noticed that on 19/7/2016, another petition was filed. Which was numbered as 480/2016. Both this petition, 443/16 and 480/16, were disposed of by an order dated 25/7/2016. And this resulted 25/7/2016, whereby the learned Labor Court held that there was no requirement for framing of a preliminary issue. And fixed 4/8/2016 for cross-examination of the management witnesses. It is against this order dated 25/7/2016 that the petitioner has approached this court by filing the present petition. To come back. Counsel the jury on behalf of the party. Mr. P.T. Roy, the learned senior counsel, appearing on behalf of the petitioner, submitted that the impugned order dated 25/7/2016 is in gross violation, is contrary to the law. Declared by the Supreme Court in the case of Shambhunath Goyal versus Bank of Baroda and others, reported in 1983 4 SCC 4911. Wherein the Supreme Court observed that the management should choose its right to exercise, choose its management to choose its to exercise its right to adduce evidence at the earliest stage and file an application for that purpose without unreasonable delay. It's submitted that the management that of the respondent number 2 in their written statement did not exercise their right by mentioning that they would like to adduce evidence. And as such, at a later stage, the management of the respondent number 2 cannot be allowed to adduce evidence to file any application seeking permission to adduce evidence. The learned senior counsel submitted that this principle have been adopted, have been declared by the Supreme Court, taking a holistic view of the matter. In as much as if there is a delay in disposal of the proceedings before the learned labor court, it may lead to wrecking the morale of the workman and compel him to surrender, which he may not otherwise do. The learned senior counsel further submitted that this law, which has been declared in the law, so declared in the case of Sambhunath Goel, Supra, have been confirmed by the Constitution Bench of the Supreme Court in the case of Karnataka State Road Transport Corporation versus Lakshmi Devama SMT and another, reported in 2001 5 SCC 433. Wherein the Supreme Court observed that the same decision in the case of the law declared in the case of Sambhunath Goel, Supra, being a long-standing decision, the same is required to be approved on the principles of stare decisis. Mr. Roy, what do you say about not framing the preliminary issue? You are challenging 25(7) has two aspects.
Lordship,
As regards not framing of the preliminary issue cannot be decided by this court now. It can be only decided after the final award in view of Cooper.
no, but it was when in their supplementary additional written statement, the management said there was an inquiry.
No, I'm not.
It was duty on the part of the labor court.
No, I'm the non-framing of the preliminary issue
Lordship,
can only be decided after the final award, not prior to the.
Because this, the tribunal or labor court has to come to this only after framing a preliminary.
Understood. The non-framing of a preliminary issue, how can this court look into it now in view of Cooper? Isn't it, Mr. Taz?
As what I have understood, the management has relied upon the inquiry as well as the merit.
No.
Only merit.
No, it was a proceeding filed under 2A.
Okay.
There was no inquiry
Hmm.
and there was no domestic inquiry.
Hmm.
So they filed a written statement. The court proceeded to giving them the opportunity to file a written evidence. He filed evidence, the other side have filed evidence. Then they said that finally have a preliminary issue decided by the workman, not the management. Normally it is the management who does it, but here the workman sought
Now,
for
whether management has conducted any inquiry, then they can adduce evidence on merit.
merit. So that is the law. That I know.
They can rely upon the inquiry as well as on the merit.
Merit.
So here they might, I don't know, might have preferred to adduce evidence on merit.
No, the question is here,
Oh.
as I had decided in another case of you, Pattabgar,
Hmm.
whether the preliminary issue has been framed or not, this can be only decided at the time of final award, in view of Cooper.
So here in this case, the no preliminary issue is required. Because
Not
the
required.
because management has not relied upon their inquiry and they had not held any inquiry.
No, it is the other way around. Here the workman is saying that kindly frame a preliminary issue.
So if they have not conducted any inquiry, then what is the utility of the framing of preliminary?
No, that has been rejected. So that was why he said. But can this be decided now when the proceedings are still pending?
Yes,
It's
there are-
academic.
No, your lordship is right. Cooper para 22. So your
So
lordship
that I can't touch it.
is- No lordship, but only thing, the whether
Now that will be kept open. But because that issue, not framing of a preliminary issue
Lord.
would not be a ground.
I can take the amendment in the final, lordship.
Final award, you may very well take that issue,
No, no.
whatever it may be, but not framing of a preliminary issue is not the ground.
High Court at this stage, no, no,
Yeah.
lordship is right. The para 22 of Cooper.
Hmm? No?
It can raise it. So this is different, madam. This cannot be decided. This.
May be decided in the main case as already issues have been framed in the main.
That is.
The learned counsel appearing on behalf of the petitioner, however, submitted that taking into account the judgment in the case of Cooper Engineering Limited versus PP Munde, reported in 1973, 1 SCC 813. Huh?
75, I think, 2 SCC.
75, na?
Yes. 661.
1975 to SCC 661, and more particularly paragraph number 22. He would not insist on the legality of the order dated 25/7/2016 for not framing the preliminary issue. And more so when the learned labor court had observed in the impugned order that the said would be decided along with the main issues. none has appeared on behalf of the respondent number 2, management. On the other hand, Mr. K. Gugoi appearing on behalf of the respondent number 1 submitted that the order dated 25/7/2016 passed by the Learned Labour Court is an interlocutory order which requires no interference at this stage, taking into account that the said issues, taking into account the limited jurisdiction which this court can exercise in view of the judgment of the Supreme Court in the case of Central Council for Research and AI versus Bickerton Das reported in so and so. And in that regard, referred to paragraph 49 and 50 of the said judgment. Analysis and determination. The materials on record, as discussed in the previous segments of the instant judgment, would show that the petitioner approached the industrial tribunal to the Learned Labour Court by filing an application under section 2 capital A of the Act of 1947, seeking redressal against the termination of redressal against the purported illegal termination of the petitioner. The respondent number 2 thereupon filed their affidavit, filed their written statement. And both the parties thereupon filed their additional written statements. It is pertinent, however, to observe that the respondent number 2 in their written statement did not contend that there was a domestic inquiry conducted the respondent number 2 also did not request in their written statement to try the validity of the domestic inquiry as a preliminary issue. Rather, it was the petitioner who sought for framing of a preliminary issue by the petition number 480/16. It is also very pertinent to observe that after the petitioner had adduced his evidence and he was cross-examined, the Learned Labour Court passed an order dated 19/4/2016 fixing 6/5/2016 for filing evidence on affidavit of the management. The record further reveals that the examination in chief on affidavit, examination chief of 14 management witnesses were submitted by way of affidavit. And it was at the time of cross-examination of, at the time when the proceedings was fixed for cross-examination of the management witnesses. The impugn order, the applications were filed by the petitioner, which resulted in passing of the impugn order dated 25/7/2016. Now let this court take into consideration the law as laid down by the Supreme Court in the case of Sambhunath Goyal Supra, as well as Karnataka State Road Transport Corporation Supra, and as to whether the same would be applicable to the facts involved in the present proceedings. In the case of Sambhunath Goyal Supra, was delivered by a bench comprising of 3 honorable judges of the Supreme Court. And the majority opinion was rendered by His Lordships Varadarajan J. Bracket, as His Lordship then was. In the same case before the Supreme Court, the facts as would appear was that pursuant to an industrial dispute, made by the reference of which was made by the central government to the Industrial Tribunal, Chandigarh. The management filed a written statement on 12th of August 1970, contending that the dispute was not an industrial dispute. The contention found favor with the learned tribunal. Which led to filing of proceedings before the Supreme Court by the workmen, which was allowed, holding that it was an industrial dispute and remanded the matter to the tribunal for expeditious disposal. In the same proceeding, upon being remanded, the learned tribunal framed two issues on the question as to whether there was a fair and proper inquiry by the domestic tribunal and whether the dismissal of the workmen was justified. The tribunal opined that the inquiry was vitiated and not in accordance with the principles of natural justice. The management thereupon moved an application for an opportunity to be given to lead evidence in support of the charges framed against the workmen in the event the tribunal holding against it on the first question relating to the conduct of the domestic inquiry. The tribunal rejected the said offer, the said application. And thereupon held that the termination of the dismissal of the workmen was not justified and directed reinstatement. It is in the backdrop of those facts the Supreme Court observed at paragraph number 16 that if the management choose to exercise its right, must make up its mind at the earliest stage and file the application for that purpose without unreasonable delay. But it was further observed that when the question arises in a reference under section 10 of the Act, after the workman has been punished pursuant to a finding of guilt recorded against him in the domestic inquiry, there is no question of the management filing any application for permission to lead further evidence in support of the charges or charges framed against the workman for the defect in the domestic inquiry is being pointed out by the workman in his written statement filed by the labor court or industrial tribunal. After the reference has been received and the management has the opportunity to look into that statement before it files its written statement of defense in the inquiry before the labor court or industrial tribunal, and could make the request for opportunity in the written statement itself. It was observed that if the management did not choose to do so at that stage, it cannot be allowed to do it at any later stage of the proceeding by filing an application for the purpose which may result in delay, which may lead to wrecking the morale of the workman and compel him to surrender, which he may not otherwise so. Paragraph 16 of the said judgment, being relevant, is reproduced hereunder. It is, however, very pertinent to observe that the judgment in the case of Sambhunath Goel was passed in the context of a domestic inquiry being held prior to dismissal or termination of the workman. And the learned tribunal, oblique the labor court, learned tribunal, had framed the issue, preliminary issue, as regards the fairness of the inquiry, which, however, is not the case in the present proceedings. The law declared in the case of Sambhunath Goel Supra was affirmed by the Constitution bench in the case of Karnataka State Road Transport Corporation, whereby the judgment, whereby the Constitution, the judgment of the Constitution bench was delivered by is based upon three opinions of the honorable judges. One opinion was of His Lordship's Santosh J, the Hegde J, bracket as His Lordship then was, wherein the opinion rendered in Sambhunath Goel was maintained, taking into account that the judgment, that the law as declared by the Supreme Court in the case of Sambhunath Goel was holding the field for 18 years. However, it is very interesting to take note of that in the opinion rendered by His Lordships, Santosh Hegde J, it was observed that paragraph number 17 of the report that the judgment in the case of Sambhunath Goel Supra need not be varied, as it was just and fair, inasmuch as there can be no complaint from the management side for this procedure, because this opportunity of leading evidence is being sought by the management only as an alternative plea and not as an admission of legality in the domestic inquiry. Paragraph 17 of the said judgment, being relevant, is reproduced hereunder. In the instant case, as would be seen, the management of the respondent number 2. It is not the case of the management of the respondent number 2 that there was any domestic inquiry carried out. In fact, it is also not the case of the petitioner that there was any domestic inquiry carried out. Therefore, the question of the management of the respondent number 2 take an alternative plea in the present case do not arise. The court further finds it pertinent to take note of the concurring opinion of His Lordship's Shivraj J. Patel, J, as His Lordship then was, wherein it was observed that though the management has to seek leave of the court/tribunal in the written statement itself to lead additional evidence to support its action in the alternative, and without prejudice to its rights and contention. But the said observations so made in the majority opinion opined by His Lordship's Sabarwal Santosh Hegde J should not be understood as placing fetters on the powers of the court/tribunal requiring or directing the parties to lead additional evidence, including production of documents at any stage of the proceedings before they are concluded, if on facts and circumstances of this case it is deemed just necessary in the interest of justice. Paragraph number 45 of the said report, being relevant, is reproduced hereunder. In the backdrop of the above, if this court duly takes note of the order dated 19/5/2016, which have been reproduced here in the previous segments of the instant judgment, it will be seen that the learned tribunal, learned labor court, had permitted the management to adduce evidence. Further to that, as there was no reliance on any domestic inquiry being carried out by the management, the question of seeking leave as an alternative plea to adduce evidence did not arise. From the facts, from the above law so declared by the Supreme and if applied to the facts of the instant case, it would be seen that the principles of law as principles of law in the case of Sambhu Naik Goel Supra as well as Karnataka State Road Transport Corporation cannot be applied to the facts of the instant case inasmuch as the management of the respondent number 2 never relied upon any domestic inquiry, nor sought for any not sought for submission, the filing of evidence as an alternative. In this regard, this court finds it very pertinent to observe, finds it very pertinent to take note of a judgment of the Supreme Court in the case of Regional Manager versus Pawan Kumar Dubey, reported in 1976, 3 SCC 334, wherein the Supreme Court observed that one additional or a different fact can make a world of a difference between conclusions in two cases, even when the same principles are applied in each case to the similar facts. So, taking into account the above, this court is of the opinion that the impugned order dated 25/7/2016 do not require any interference, more so in exercise of the tertiary jurisdiction of this court, which can only be exercised when the jurisdiction is being exercised without exercise in a palpably erroneous manner, or when an authority is exercised having no jurisdiction have exercised such jurisdiction, which is not the case in the present case, which is not the present case. Considering the above, the instant with petition stands dismissed. Cost? The cost impose that to be back. Return the LTC.
Item 5,
Yes, no matter, I have it on 21st. Nobody had appeared. Yes, item 5, Mr. Dasgupta, your matter. Hey, high time we finish this matter. Because there are a lot of, what do you call, insects which is coming out.
So seriously, we can take that 2 minutes.
Huh?
That 2 minutes.
What are you challenging?
It is almost 12:56.
You start with,
My case will not take much time.
Mr. Dasgupta, you start with 2-letter or 4-letter words out here. So that once it starts, otherwise 2 o'clock I've got a lot of matters. Then you have to wait till 3 o'clock. So do you want to take the advantage of the 3 minutes so that I will be in a continuing the hearing?
Milord, in this case, what happened? The matter pertains to revision of wages of Brahmaputra Valley Corporation, fertilizer corporation. They are not in a good shape. This is not a profitable concern, Milord. So Government of India issued a circular directing the all public sector undertaking that the public sector undertaking who are not in a position to pay the scale of revised scale of pay, they should not pay it. According to them, that if the revision of pay scale payment for the revision of pay scale exceeds the 20% of the profit, then they should not revise the scale of pay. And their employees' scale of pay or employees' wages will be determined by the direction to be issued by the government of India from time to time. Now, what happened here in this case, Milord? On 5/4/2013, the government of India's Ministry of Finance, Fertilizer and issued a circular to the effect that they can enhance the basic wages of the workmen to the extent of 20%.
That is page 64.
Yes, to the
I'm
extent of.
directed to refer to your letter dated on the subject cited above and convey the approval of the Honorable Minister for grant of DA works any and on 20% of the basic pay as on so and so with effect from so and so to all regular employees in lieu of fixed amount of equal to 20% of demand on existing scale of so.
Yes.
Of the above increase have to be borne by the company from its own resources and no budgetary support will be provided. Now we are concerned with which company?
No, Miller, what happened here? Only basic wages was granted.
Huh?
Enhancement of basic wages. No other part benefits like PF and other benefits, allied benefits.
Now what do you want?
Now, Miller's subsequent circular was issued in the year 2016.
To the effect that shall be applicable from 1/1. So you want it from 1/1?
2010.
They have given it from 1/6/2015.
Yes. Initially, they have given it, you'll also come to page 63.
But
Yes,
how
page-
does this court exercise such jurisdiction?
No, that
If
is not
they
the
don't have
problem.
the money?
Your Lordship, come to page 63 first, then it will be clear.
Page
63, first order. That is order dated 5th April 2013. I am directed to refer you the letter dated such and such, subject mentioned above, to convey the approval of the competent authority and increase in the pay of regular employee by a fixed amount equal to 20% basic DA of individual existing scale of pay with effect payable with effect from 1/1/2010. Only DA and basic. That was granted.
now they have made this.
Now,
20%
they have given additional benefits on DA, on basic. And the additional, you'll come to page 64. I am directed to refer the letter dated such and such, subject under the approval of the Honorable Minister's Fertilizer grant of DA, parks, any allowance. And earlier, they only granted DA. No any allowance, no parts. Allowance was not granted. Now, though they have granted these parts and any allowance on basic and DA, but that was not extended from 1/1/2010.
But if we understand it, 20% of the basic and DA means it is the inclusion of basic plus DA.
Yes.
There the 20% would be given.
Yes.
Which means, just for example, as of now, if 100 rupees is the amount and we are going on the DA being given at 2%, it will be 152, of which 20% would be given as the additional perks. That is what.
Yeah.
But here what they have done is, for grant of DA,
Yeah.
parks, that means these will be done on the basis of 20% of the basic without taking the DA.
So initially, they only granted DA and basic,
No.
no other parts.
No, I think what they have done is they have reduced.
Right.
Because it appeared your basic will be always less, taking into account the PT. And when you are considering about 1/1/2007 bank, it be as per, I think, the 6th pay commission. The 6th pay commission, if it was done under the 1/1/2007, then in that regard, the DA by then 2015 or 16, whatever may be, must have gone pretty high. Now the DA component is being taken out. So you are given 20% only on the basic.
Only on
But
basic.
these people, for these 20%, on the basic will be taken for the purpose of calculating your DA.
DA only, DA and basic.
DA, perks and any allowance. So this is obviously less.
Yes.
There's no concept because earlier it was 20% of basic plus DA.
Yeah.
Therefore, I was saying 100 plus 150. So 20% will be around 150. 20% will be around how much?
Now, this basic and DA,
30 rupees. 30
Ah.
rupees would have been the earlier benefit. Now, if it
The-
is so, it will be on
they
100
include
rupees.
Provident Fund as well as the NF.
That I understand. 100 rupees is the thing, of which 20% will be 20 rupees.
Yes.
So these 20 rupees will be calculated only for the purpose DA.
Yes.
So your DA amount which is there, so it is only for the calculation of DA. The DA would not be calculated along with anything, which is always normally it is there. The
Yes.
DA
That
will
was,
be only 20% of the basic.
yes.
So they are not putting anything else. Perks, they have whatever maybe.
Provident Fund as well as the any allowance. That
So
was
this-
not granted.
This is less.
Yes, this is that.
So for that we have come before.
Yes.
Yes. But how do I help you? Anyways, let me come back.
Yeah.
Yes, Mr. Mani, what do you have to say?
Well, I had a word, my colleague actually had a word with the client, and they had paid with all humility with her, that if there could be one chance for mediation, else whatever your lordship pleases me. Because so far as reinstatement part is concerned, since they've alternatively also prayed for some monetary things, if they could work out on that. That's a very humble prayer. We leave it to your lordship.
Okay, we will pass an order for mediation. One thing when we can do good and bad is that ask that.
Other
Are
side
you
is there.
willing to go for mediation? Huh? We'll have it at 3 o'clock.
Sure. Obliged.
Take a mediation.
I'm so very grateful. But
Yes.
Now, Lordship may kindly consider the affidavit filed by the respondent number 2. The Government of India.
Yes.
Page 9, the office memorandum. This is the basic document. 26 November 2008.
Page
9, internal page, of course. From respondent number 2.
Yes.
Now, this is an office memorandum. Now, clause 3 and clause 4 are pertinent. So far we are concerned, we are covered by clause 4. So let me read clause 3 first. The revised pay scale would be adopted subject to the condition that the additional outgo by such revision for a period of 12 months should not result in more than 20% dip in profit before tax for the year 2008-7-8 of a CPSE in respect of executives as well as of non-executive unionized supervisory staff taken together in a CPSE that cannot afford pay full package can implement with either part of PRP or no PRP. This CPSE may pay the full package subsequently provided the deep profit in the PPD is fully recouped the original level. The organizations who are capable to pay the salary of the revised scale, they will pay. Provided that for payment, for due to payment, they should not exceed the 20% of the yearly profit. But we are not covered by this. We are covered by clause 4. The CPSE, which are not able to adopt revised pay scale 2007, may give an increase on the basic pay plus DA drawn in the pre-revised scale on 1/1/2007 with uniform lower fitment of 10% or 20% depending upon the affordability with the approval in their ministry or department. So only those persons who are not profit earning organization, they can be given some benefits up to the extent of 10% or 20% dearness allowance and basic. In the pre-revised scale. So when this 10 or 20% basic is given to a pre-revised scale, its consequential benefit will also arise. The consequential benefit is to the extent of provident fund and northeast allowances. But that was not given to us. Only DA and basic was extended.
Kindly come to page 4 of the affidavit.
Page 4 of,
The affidavit.
yes. Paragraph 9.
Where I, top portion.
Hmm. The CPSE which are not able to adopt revised pay scale 2000 may give an increase on the basic plus DA drawn in the pre-revised scale. So that is very much important, drawn in the pre-revised scale. So we have to give 10% basic pay and DA that will be adjusted in the pre-revised scale. When the basic pay DA and the basic and DA is adjusted.
Kindly say, accordingly, an increase in the pay of the regular employees by a fixed amount equal to 20% of the pay and basic of the individual on existing scale as on so and so payable with effect from 1 year was granted with the approval of the competition authority by the Department of Finance by letter and as per the provision. Then this is being given to you on the basis of the 2013 letter.
Yes, 2013 letter. Only basic and DA was
So
granted.
this has been given to you.
Consequential benefits arising out of basic and DA was not granted. But this consequential benefit arising out of basic and DA was granted in the year 2015.
13.
No, 2016. That is page 64.
Then paragraph 9 with regard to the stated that the department by the year conveyed the approval of the computer for grant of DA work and allowance the year payable or there with effect from all the regular employees in view of so and so.
With effect from 1/6
by
2015.
13.
Consequential benefits. So only consequential benefits were extended in the year 2015, not in the year 2010.
2010.
Only basic and DA.
No, the individual as on existing year payable with effect from one was granted with the approval. Now, did you get the amount as per this annexure 1? Yes, we are paying for response number 2.
Yes,
Yes.
my lord, I have submitted the affidavit in opposition. Kindly
is what
turn
we
to
are-
page number, page 3, my lord, paragraph 8.
Yes, that is the.
Constant clause in by the, this I have
My
read.
affidavit, my affidavit.
That I have read it.
Paragraph 8, my lord.
Now tell me, Mr. Shakar,
Just, may I read?
I have read it. Okay.
That with regard to the statements
Mr.
made in
Sharma,
paragraph 5.
Mr. Sharma,
Yes, my lord.
I have already read that. I don't want you to read it again. You say in paragraph number 8 that there was a loss which is being
Yes,
incurred by
loss,
the
yes.
respondent number 1.
Yes,
The question of making payment or applying the first clause
yes,
or clause number 3, it
Clause
is
number
not
3.
right.
yes, yes,
However, in terms with clause number 4,
yes.
you have given some benefits with effect from 2010 as it appears.
Yes,
Thereafter, you have again, in the year 2016, on the basis of the approval being granted by the competent authority, you are giving them the basic of 20% in lieu of the fixed equal of 20% of the basic pay and DA on the existing year granted earlier by so and so. Now you are giving this benefit of approval of the month from so and so DA any and year from
Yes.
2015 on.
Yes, as per Annexer D, 16 ultimately.
Therefore, your study.
Yes, with effect from 2015, they are entitled to get. Later on, it is as per that letter it is given. Now, my respectful submission before this honorable court. Now, as per whenever the BBFCL, they are continuous, they are in loss, and that's why they were not in a position to whenever 20% dip in profit, they should not result in more than 20% dip in profit. That means dip in profit means generally refers to a period where the price of an asset like has decreased temporarily, but with the expectation that it will rebound and increase in value and again. Then if it is regained, then they can pay. Because no budgetary payment will be given from the government. They'll have to give, they'll have to from their profit. Now my respectful submission before ultimately what happened in 2000, by this letter, it is, Lord say kindly say last annexer. It is admitted fact that the annexer D that with effect from 2015, they are entitled to get 20% basic pay provided there must be a 20% profit, dip in profit, rebound and increase. It will up to them. They will have to pay. Now, Lord say kindly see last annexer of my affidavit. Annexer 2, page 18, my lord. Page 18. The implementation of, may I read, Lordship? Implementation of 2007 CPFC scale in BBFC, that is the subject. The scales of pay of the incumbents of the board level and below board level executives were last revised by the government with effect from 1/1/97. The government of India decided to revise pay for board level and below board level executives and non-unionized supervisors in CPSCs with effect from 1/1/2007. By DP's official memorandum, the date 26/11/2008. That is Annexer 1, my lord, page 9, which I have annexed. That's my learned stated. Which was to be implemented through issue of presidential directives. Presidential directives, Department of Public Enterprise by their official memorandum dated 9/2/2009 and 2/4/2009 has further revised the existing guidelines issued by their official memorandum dated 26/11/2008. Now, para 2, your lordship. The matter regarding implementation of 2007 CPSC scale in BVFCL was examined in consultation with Department of Public Enterprises DPE. DPE by official memorandum dated 7/11/2017 has referred that the cabinet has already approved the implementation of 2007 pay scales in BVFCL, for which BVFCL has to comply with the provisions of DPE official memorandum dated 26/11/2008. That means at clause number 3, they'll have to comply of the 26/11/2008. The Department of Fertilizers may ensure that in the instant case, the conditions of affordability for pay revisions as laid down in para 3 of DPE's official memorandum are fulfilled by BVFCL. As for the effective date of pay revision, para 17 DPE official memorandum dated may be referred to. Lord, say kindly again turn to page number about para 17. Para 17, my lord, page number, page 11, my lord, page 11 of the official memorandum. 16 and 17, financial implication. The CPSC's concern has to bear the additional financial implications on account of pay revision from their own resources. That is, no budgetary support will be provided by the government. Number 17, your issue of presidential directive, effective date of implementation and payment of allowances, etc. The revised pay scales would be implemented by issue of presidential directive in respect of each CPSC separately by the concerned administrative ministry department.
Wait. Kindly come to that document fully. You have rushed from here to there. Kindly come to page 18.
Oh, yes, page 18, my lord.
So what
Now-
are the directions given? The wage revision proposal of BPHL will be only for revision of pay scales and basic pay. The revised pay scales are implemented with effect from 1/6/2015
15 only?
However, revised pay scale will be notionally fixed with effect from 1/1/2007.
Oh, yes.
So it will be applying this,
Temporarily.
will have a bump in their salaries. But they would not be granting any notional payment. Shall not
No,
be
sir, no, sir.
The actual payment of the revised salary will be made with immediate effect, that is, with the date of issuance of the
Presidential
presidential directive. Presidential directive is dated,
No arrears shall be paid for the,
presidential directive is dated 2009, isn't it?
yes.
No arrears shall be paid for the period from 1/6/2000 to the date of the issue of these presidential. So this is a presidential directive.
President, there is, I have.
No, no, is
paragraph 17.
annexed to a presidential directive.
Para 17, my lord, of
The
the.
exercise of the
President
prayer, the president,
Annex number one.
oh, so this will be given from there. This is being done in 2018. No arrears will be paid for a period from 1/6 to the date of issuance of these precedents. HRA and AR will be paid on revised basic pay as applicable, interim relief and so on. Okay, now this is what you are going to give them.
Yes, yes.
You will be giving them with effect from 12th of January 2018.
With effect from 1/6/2015.
What 1/6/2000? You are giving it from the revised are implemented with effect from 1/6/2015 only. However, revised pay scale will be notionally fixed as on 1/1/2007.
What
The
are
actual payment of the revised salary will be made with effect, with immediate effect, meaning thereby from date of 12/1/2018. With the date of issuance, no arrears shall be paid for the period from 1/6/2015
Yes. Now, actually,
to the
this
date of
letter was.
issuance. So from 1/6/2015, it has been implemented.
Yes.
But it appears that from 1/6/2015, the revised pay scale has been implemented. And these revised pay scales are to be notionally fixed from 2007.
1/1/2007. Yes.
And it would be payable only from 12/1/2018.
2018, decision was made by this letter on 12/1/2018, but with effect of retrospective effect.
From?
1/6/2015.
Here, how do you take care of this? No arrears shall be paid for the period from 1/6/2015 to the date of issuance of these presidential directives.
Yeah.
Then how are you saying that you are going to pay from 1/6/2015?
Now, my lord,
HRA and admissible will be paid. Interim relief, no budgetary support will be provided from the government for implementation of the above while implementing the other terms and conditions of the 2008 has to be strictly adhered to. The issue is approval of the Honorable Minister. So this you have given. Now what is the case of the petitioner here?
but my lord, another very
Petitioner has
important
not
point. I
challenged this
want to draw
approval.
the attention of this honorable good. I want to draw the attention of this honorable good. Yeah, very important point. That my learned the senior he has stated that regarding and one annexer, one management, one minutes, page number 65, your lordship, of the writ petition. Page 65. Kindly turn to page 65. Here, minutes of the meeting held between representatives of BVFCL, management, and members of both the regular unions of BVFCL employees on 11/6/2016 in the conference hall of administrative building of BVFCL. A meeting was organized at the conference hall of administrative building on request of both unions regarding implementation of 20% of basic pay, and the following were present in the meeting where OSD was also present. Here from management side, 3 persons were present. From unions also 4 persons are present. Now, at the very outset, GM welcomed all the members.
Mr. Sharma, why are you referring to this?
Here, my lord, here.
No, come to the
management.
point.
Here.
I am not going to read it.
No, here, my lord.
Yes, why?
Paragraph 1, I want to submit.
Mr. Dasgupta is not referring to this. Why you are referring to this?
No, yes, I am referring here, management representative confirmed the unions. that
Mr. Sharma, kindly appreciate
Yes,
one thing.
sorry.
The payment of any PSU has to be made out of the coffers of the PSU.
Yes, yes.
There's no quarrel with that.
Okay.
Unless there's a grant in aid being given by the government of India, that's a different aspect. Now, the government in 2008 came up with a policy that look here, those persons who are having no problems in making payment, they can very well give it without affecting the 20%, even without, if there's a 20% dip in the profit also, if it is not affected, then you can go ahead and make the payment, whatever may be. But if you don't come within that ambit, then you have to pay this particular amount. This is clause 4. This is done in 2008.
Yes.
Now, thereupon the question arose, they were given in 2000, from 2010, as you say, on the basis of a letter dated of 5/4/2013, this was being given.
Yes, madam.
Thereupon, after some time, in 2016, on the basis of the competent authorities here, you have given them at 20% on the what you
PF.
call the
PF
basic, on 20% of the basic, you have calculated the PF, DA, and all these things, which you have given from 2015. Now comes in 2018, this issue again went to the central government, and the central government passed an order in the year 2018. And look here, you are to give the benefit in terms with the 2007 pay revision, notionally fixing it from 2001-2007, but implemented from 1/6/2015.
15.
But the payment will be only affected from 12/1/2008.
Payment, payment will be made.
So I think I am clear with the facts.
Here, Lordship.
Now, okay, I have heard you. Take your seat.
Right.
Mr. Dasgupta, what is your quarrel now? Without a challenge to the 2018, what they have done, how do you maintain?
No, I am not challenging. I am rather, relying upon this. What is the
Now being given, whatever it is, in 2018, they look into it, that okay, now you will be given only from 2018, 12/1/2018.
No, we are not concerned the 2018 because all the petitioners are retired between 2010 to 2015. So we are not concerned with the 2018. It is immaterial.
Now, what are you concerned?
When we were in service, we got only DA and basic to the extent of 20% in our scale of pay. Now, when a scale up when DA is enhanced or basic pay is enhanced, then consequential benefits of provident fund has to be given, and the NE allowance has to be given. But these two allowances were not extended to us, and these were extended in the year 2015 only. But in the meantime, all these persons retired, so they could not avail these things. So our prayer before your Lordship is that when you have given the basic pay or the dearness allowance, the consequential benefit in our scale of pay, it is specifically mentioned, basic pay and dearness allowance in the revised scale of pay. When the basic is enhanced in the revised scale of pay, when the dearness is enhanced in the basic pay, scale of pay, the consequential benefits of provident fund and any allowance are to be enhanced. But it was not enhanced, but this enhancement was made in the year 2015 only. So thereby we were deprived of. Had it been enhanced in the 2010 or the effort would have given, then our gratuity amount would have been enhanced. Our provident fund amount would be.
Now, what is your basic case to submit or to contend that this particular amount should have been included in, or it is mandatory to, when you are giving the 20% basic hike, only you can't only limit it to basic as well as the DA, but you also need to look into in respect to the other allowances.
Like provident fund and any.
Yes.
Only two allowances were given, other allowances were not given. And the effect of these two allowances were given from 2015, not
Understood. I understand. It has been given from 2015. But the question is, what is your basis on which you contend that you are entitled to? Because you see, the payments are to be made on the basis of the coffers which the company has. Now, is there any rules or regulations to the effect that whenever you increase your basic as well as the DA, the consequential effect has to be felt upon the PF contribution
Yes.
and all these things?
Yes.
Where is it?
Whenever in a scale of pay,
No. Every scale of pay, it has to be stated out there in the ROP.
correctly, yes.
Now, where is it in your ROP that you have to be getting that? Show me that. This is your basic case. If you
Yes.
want to get it,
So
you have to
big-
show me something. Somewhere the flow has to be given. The question of,
Provident Fund Act itself. So for the Provident Fund Act is concerned, my lord, Provident Fund is computed on the basis of basic and the NS allowance. But this calculation was not made.
no, where is it? Show me.
The Provident Fund Act.
You have to show me that if there is an increase
In
in the basic, there has to be a consequential increase in the PF contribution.
Yes. That's section 6 of the Provident Fund Act. But so far any act is concerned, I don't have any case. Because so far any act, Northeast Allowance Act is that is not regulated.
Allowance Act, you will not, I mean,
That will not.
you
be-
may have a case in.
I may have a case
statute,
on, I may have a case on Provident Fund only.
because that may be brought within it
Hmm.
to the effect that, okay, provident fund, it has a correlation.
Yes.
That if there is an increase, there has to be a consequential
Yes.
increase on the PF contribution.
Yes. This much I can argue, I can't argue on any other.
Yes, Mr. K. Kolita. J. Kolita.
Provident Fund Act, one more time.
The basic case of the petitioner is not that what has been argued by Learned Senior. The basic case.
With the
is para-
age,
para-
you
12
see, we
12.
also go by the aging of wine to the matters of this importance when it is already 9 years.
Not it
Yes.
says. The relevant paragraph is the predate
I
case of the
can argue
petitioner is the
Provident Fund
para 4
miscase.
as well as the para 12.
Huh?
Paragraph 4 as well as the paragraph 12. Not it.
Oh,
The petitioner predate case is that
1950.
paragraph 4 as well as paragraph 12. The petitioner is harping on the settlement lordship that was never implemented till date lordship. So petitioner is praying for something on the basis of the settlement lordship, and that's for lordship as per the judgment of the Honorable Supreme Court lordship.
No, this settlement cannot be applied.
But paragraph
No,
12
I cannot
lordship-
argue this settlement because of the fact there is a clause in the settlement itself. The subject to the approval of the government. So I am conceding your point.
so you say that you come under the Public Provident Fund Act,
Yes.
so it has to be withdrawal, the subscription, the contribution has to be, subscriber, subscription, any individual may on his own or on behalf of minor or whom he is the guardian subscribe to the fund in the manner subject to such maximum meaning.
Maximum limit is probably 12%.
Huh?
Maximum limit is 12% probably.
No, but if you have a volition to submit, how much it should be going there?
That depends on the organization. Maximum limit is 12%.
No, you said it 12%.
Maximum limit.
Maximum.
It
But-
may be 10%.
But if you are, because you need a subscription to the fund. So there is a volition
Yes.
on your part that you will voluntarily give this particular from your income.
Yes.
Now you are therefore submitting that if your basic is increased,
Or basic and DNS.
is increased,
Hmm.
you would have submitted more.
Yeah.
Or you have to subscribe more.
Employer's contribution is equal
It will
to
come under which act? Employees Provident Fund
Fund
Miscellaneous
Miscellaneous Act,
Provisions Act, 1952.
1952.
Okay, let us see how it is being worked out. You're referring to section 6,
Probably.
contribution and matters in which have to be provided. The contribution which shall be paid by the employer to the fund shall be 10% of the basic wage, earnest allowance and retaining allowance for the time being payable to each of them, whether employed by him directly or by the employer shall be equal to the contribution payable by the employer in respect of him and may if the meeting is subject to the so you therefore say the employer's contribution shall be 10% of the basic of the dearness allowance of the basic wages. 6 was brought in. And dearness allowance and retaining allowance, if any. So if there is an increase in the basic wage and the dearness wage,
Automatically.
there is an automatic increase in the provident fund, in the 10%. Whether you have submitted or not,
That is
but,
different.
it's a different thing.
Hmm.
But it is bound under section 6 for the employer to do so.
This much I can argue, I cannot argue
No, it's okay.
anything more.
No, Mr. Dasgupta, put this by way of an additional affidavit as there is no pleading to their effect. Put it by way of an addition because you see,
Yes.
I'll pass an order in your favor. Tomorrow he will come up. This is not a pleading list.
Yes, yes.
Huh?
Sometimes one crops up all of a sudden. That is what happened when I was sitting before your.
So you file an additional affidavit. I give you the opportunity so that I give him an opportunity to rebut. Then I think, then he cannot later on say then no. Isn't
This
it?
much I can argue, I can't argue anymore. Anything more.
Heard Mr. A. Dasgupta, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. S. Sharma appears on behalf of the respondent number 2 and Mr. K. Goilka appears on behalf of the respondent number 1. The petitioners herein have assailed the order dated 30/5/2016 passed by the Undersecretary to the Government of India, Ministry of Chemicals and Fertilizers, Department of Fertilizer. On the ground that the impugn order only grants benefit with effect from 1/6/2015 and not with effect from 1/1/2010. The grievance of the petitioner herein is that the petitioners have retired. The petitioners herein have retired prior to 1/6/2015, isn't it,
Yes.
Mr.?
They retired between the period 2010 to 2015. I have given the particulars.
Prior to 1/6/2015.
No, Lordship. Some of the petitioner after 1/6/2015. Because as per their case 29 in a sort of serial number 5, his retirement 7/2015, 24/10/2015, 32/1/2016.
Inasmuch as most of the petitioners have retired prior to 1/6/2015, and some would retire immediately thereafter. Mr. Ida Gupta, the learned senior counsel, submits that the reason why that he would limit his submission to the fact that the allowances insofar as the PF contribution is concerned should be given effect from 1/1/2010 inasmuch as by the communication dated 5/4/2013. The respondent number 2 have increased the pay by the pay of the regular employees by a fixed amount equal to 20% of the basic and the DA on the existing scale as on 1/1/2007, which was made effect from 1/1/2010. The learned counsel drawing the attention of this court to section 6 of the Employees Provident Fund and Miscellaneous Provisions Act 1952 submits that the said provision obligates the employer to pay 10% of the basic wage, dearness allowance, and the retaining allowance, if any. And therefore, the learned senior counsel submits that with the increase in the basic and the DA, with effect from 1/1/2010, the contribution of the respondent number 1, who is the employer, has to also increase insofar as the contribution of the respondent number 1 towards the payment to the fund has also to increase consequently. Mr. K. Gultai, appearing on behalf of the petitioner, respondent number 1, however, submits that this is not the pleading case of the petitioner. And as such, the respondent number 1 had no opportunity to deal with the said submission. The learned senior counsel, appearing on behalf of the petitioner, however, submitted that the same case which have been contended herein can be seen, would be apparent from a reading of the communication dated 5/4/2013 and the impugned communication dated 30/5/2016, read with section 6 of the Employees Provident Fund and Miscellaneous Provisions Act 1952, and therefore submitted that the said being an aspect pertaining to law, it can be raised at any stage of the proceedings. This court, having heard the counsel, is of the opinion that an opportunity should be granted to the respondent number 1 to rebut, to state on affidavit, to bring their stand by filing an affidavit as to whether, as regards the applicability of section 6 of the Act of 1952 towards the contribution of the respondent number 1 for the fund, if the basic have been increased, basic as well as the DA had been increased by 20% as mentioned with effect from 1/1/2010. You find. List the matter when 2016 matter. Tomorrow.
2 weeks.
What 2 weeks?
No.
You will laugh.
Namru.
Huh?
Namru proceed 2 weeks.
Oh, it takes a long time to go there.
Namrup, Lord.
That's right.
Very far off. Somewhere nearby. Which continent? Not yet.
That matter 3 is not.
It's the matter on 9th of September 2025 at 2 p.m. The affidavit be filed by 1st of September 2025.
Hello.
Admission item to fixed at 2 p.m.
Only this, there might be, Mr. Kulita, the increase will be not much. It is at the end of the day, because with the 20% increase, the fund is 10%, you see. We are concerned with an increase by 20%, that too for 10%.
Hardly 25,000.
Huh?
Hardly 25,000 hardly. Probably.
Or more than that. At the end of the day, these people may have some consolation of fighting and litigation for the last so many years. Otherwise, he has given up with that. Yes, what is this? Simplex. Okay.
Well, the challenge in the writ petition is the termination notice. Lord, I'll be very brief, my lord, so far as the facts are concerned, because my lord, the question in issue is very short. Lord, my clients, my lord, they entered into a contract, my lord, for deployment of an oil rig. Now, my lord, there was an initial delay in deployment of the rig. A show cause notice was issued saying that, all right, if you do not mobilize the rig within a particular date, we are going to terminate the contract. Now, there were exchange of correspondence. 1 day beyond the cutoff date, the rig was deployed, and they were happy with that. And I was also given the permission to start work. Now, there is no dispute that the rig was mobilized completely. Thereafter, after I mobilized the rig, comes the termination notice on a completely different ground, saying that the part of the diesel engine, which is a part of the rig, it is, rigs are operated by, diesel generators. So part of the diesel engine, which in the third party inspection you had said was lying in your site, it was lying in another of the Oil India contracts. Therefore, you have falsely stated a fact, and therefore we are terminating it on this ground. This is the sum and substance of the termination. We come up challenging it. Our point was twofold, that it was all along known to you that that part was lying in the All India site, and I shall at the Oil India site in the earlier contract, and I shall show it from the third party report. And second, to counter that, they say you have written a letter saying that this diesel generator would continue to be there till the end of that contract. This is factually where we stand. Kindly see, I'll show your lordship only 5 pages or 5 documents. Kindly first come to the mobilization notice, which is I'm sorry, to the mobilization notice dated 28th March 2024, which lordship will find at page 30. 30. The lordship will mark the date. It is dated 28th March 2024. I need not trouble your lordship with the entirety. 28th March 2024, and they have drawn our attention. Lordship will find drawn our attention to para 2. As per part of civil ancillary job, you are requested to provide required panel fencing and so, and then special conditions, and that is there. And clause 4, as specified in tender clause so, company intends to inspect the rig package before mobilization. Thus, complete rig package should be offered for inspection to be carried out by the Oil India team prior to mobilization with at least 1 month notice. So, before it is mobilized, inspection is carried out. Now, admitted position, there was a delay, and lordship will take the next document at page 52, which is 5th May 2025. The subject, But I read from para 1, the subject contract was awarded to you with a LOA number so and so for charter hire of so and so. Mobilization of the rig was required to be completed within 120 days from the date of issuance of the mobilization notice. Mobilization notice against the rig was issued on 28th March. As such, mobilization against the contract was required to be completed by 26 July 2024. However, mobilization against the contract has not been completed even after 403 days from the date of issuance of mobilization notice. That is lapse of more than 280 days from the scheduled mobilization completion date of 26 July 2024. Then my lord, kindly come to clause 5. By, my lord, I read the bold portion. By not completing mobilization against the contract even after 403 days, you have failed to honor contractual obligations, causing loss to company operationally and financially. And ultimately, my lord, lordship will come to clauses 7 and 8. In light of the above, you are requested to take necessary immediate corrective steps to complete mobilization in all aspects within 20th May 2025. So, my lord, time is extended till 20th May 2025. If mobilization is completed within this date, you will be allowed to continue the execution of the contract, but applicable LD will be imposed against the delay. So, there is extension with imposition of LD. Please treat this letter as termination notice in case of your failure to complete mobilization within the timeline, that is within 20th May. Then, my lord, kindly see the 20th May letter. That the rig had almost reached, there was some difficulties. So on 20th May, they extended by 2 days. Page 55. Page 55. I read from the second paragraph because we had informed them on 20th what was the position. Now, with your email of 20th, you have submitted revised timeline confirming to the complete mobilization by 26th May. So, my lord, 5 days, 6 days more was sought for, addressing the observation or shortfall pointed out by Oil India Limited during the inspection. So, my lord, inspection takes place, shortfall pointed out. Now, based on your commitment and considering the progress of mobilization as on date, so they are satisfied with our mobilization progress. Oil management have extended the timeline and completion of the mobilization indicated in the termination notice from 20th to 26th. Please note, this shall be final extension should you fail to complete mobilization in all aspects within 26th May of the contract shall terminated with effect on 27th. Now, there is no dispute that, my lord, the rig was mobilized within the extended date. 26th May, my lord, it was done. There is no dispute. Lordship will find that in the letter of 26th May. Kindly come to page 56. This is after the mobilization is complete. In reference to a letter of so-and-so, the mobilization status of your rig was inspected. In connection with the following rig equipment, we would like to submit as under. Then, my lord, the serial numbers of the engines have been mentioned, and, my lord, 2 other parts. As per TPI, my lord, TPI here stands for third party inspection report. TPI is third party inspection report. So kindly marks the date of the TPI report. As per TPI report of 24th July submitted against tender so-and-so, the contract was awarded. Above mentioned equipment was physically inspected by the TPI agency on 3rd July at so-and-so Batua Charaidev. However, it seems that the equipment mentioned above were actually operating under contract number so-and-so in Dima Hasao during the particular period. Thus, the information provided by you in the said TPI report submitted against tender so-and-so does not align with the actual practical status of the rig equipment at the time of submission of the bid and appears to be factually incorrect. Considering the aforesaid facts and development, oil is now of the considered opinion not to allow to commence operation, and accordingly, the completion of mobilization of your rig is kept in abeyance till further notice. In view of the above, you are advised to clarify your stand on the above discrepancy of committing the same equipment against one tender when the equipment is under obligation in another contract, which appears to be wrong and false declaration, you are requested to submit your reply. Now, my lord, I submit my reply. Before I take your lordship to the reply, Lord, kindly have a look at the third party inspection report. Lord, the report is at page 60. And my lord, third party inspectors, my lord, it's a panel, my lord, which, my lord, Oil India appoints, my lord. We are only to, my lord, get it inspected from the panel. We have no control over how they couch their report or what they say, but I shall show from this report that they had inspected the rig at the site of Oil India itself. Well, at page 60, Lordship will find, my lord, towards the middle, inspection location. Well, because, my lord, the rig, well, this was an idle rig which was lying at Batua Moron, which is, my lord, my site, my godown. So, my lord, bulk of the material was there, but, my lord, kindly come to page 62. The third party inspectors go to the Dima Hasao site and they take photographs, and, my lord, when they at page 62, kindly see second last paragraph. According to requirement of Messrs. Oil India tender so-and-so, following list of document verified with original and reviewed and rig model number so-and-so and equipment items physically verified and test certificates reviewed at Messrs. Oil India / Simplex site assigned. So, my lord, the entire rig was lying at our site, but, my lord, so far as the engine is concerned, it was there because admittedly Oil India's another contract was operational. My lord, I am not disputing the fact, I disclosed this also. Important fact is, my lord, this engine was of 2000 horsepower and the contract requirement at Dima Hasao was 1500 horsepower. Now, my lord, what was my virtue subsequently turned into my vice, because, my lord, since this was lying idle, and I have, my lord, my credentials are, I have completed 4 contracts of Oil India prior to this contract, and my exclusive rigs are used exclusively for Oil India. I don't have any other client. I only have 2 rigs, one with an engine of 1500 horsepower and another 2000. So, because, my lord, first at Dima Hasao, and it's an admitted position, the Dima Hasao contract required 1500. But because, my lord, there was difficulty in getting availability of spare part, there was difficulty in the engine. On 17th March, I opened up the 2000 horsepower engine and I had shifted it over. So, the contract doesn't suffer, and at a higher power machine, it works at a faster pace. And when I apply for this contract, my lord, I make it clear the third party inspectors, my lord, inspect this, and the photographs are of, it is the engines are inspected at the Oil India site also.
In respect to where you were asked to mobilize.
No, my lord, we were asked to Dima Hasao, my lord, I'll just make it more simpler. Dima Hasao is the site of a prior contract, which has now been completed. And, my lord, it was completed sometime in September 2024, actually, with delay, but it is completed. The Dima Hasao contract required an engine of 1500 horsepower. Now, my lord, admitted position 1500, my lord, there was some difficulty in the engine, and, my lord, repairing it would have taken some time. So, as an interregnum in the arrangement, this was lying, my lord, the other rig of mine was lying at Batua Moran. I opened the engine from there. I had taken it over there and I replaced it. And my letter is there of 17th March 2024 that I am replacing it with a better and more powerful equipment. Kindly allow this, because, my lord, they noticed that there was a difference. There is no dispute with regard to the Dima Hasao contract.
And
it has been completed. Now, my lord, the issue is with regard to, my lord, this contract, where, my lord, there was a delay. And, my lord, I have taken your lordship to this. It was mobilized.
You brought this 1000 horsepower engine. If you used it for the Hasao project and brought it out there for this project.
Yes.
Now, their case is that how you are doing this particular project here, which you are using it there in the
Yes, that is perfect, my lord. That would have been an issue that would have been an issue if the case is that the delay is because of this. Because, my lord, over there in the meantime, the 1,500 horsepower engine was ready. But I did not, my lord, I did not replace it because I did not have any contract of Oil India to open the 2001 and, my lord, take that and put that 1,500. 1,500 became ready within a month. But, my lord, my object was, my lord, to do it at a faster rate and complete the contract. So I had kept the 2,000. And this issue was never raised. Lordship will not find, my lord, right in 23 or 24 or even in May 25, this issue being raised at all. That this is being done there. Because, my lord, so far as I am concerned, my lord, my clients. Yes, my lord.
You brought the 2,000 horsepower engine to this contract. This is which place is this?
DJS Namdu, sorry.
It is Namdu.
Namdu.
So you got that 2,000 horsepower engine out here.
And, my lord, I bought it out here, my lord. That contract ended in September. So, my lord, September 24. So, my lord, this itself, why I mention this fact, my lord, this, my lord, in the opposition, my lord, the color which they are trying to give, as if, my lord, because of this delay, I have delayed this mobilization so that I can utilize the 2,000 horsepower engine over here also. And this is where, my lord, whatever language they say that I have made a misrepresentation or a harsher language has been used. But, my lord, kindly note that the Namrup contract was completed in September 24. And, my lord, this was mobilized, my lord, Lordship has seen in May 25, my lord, they are giving the notice, my lord, that the cutoff date is 20th, which is extended till 26th. So even, my lord, 8 months thereafter had expired. Because, my lord, the issue was, and, my lord, the delay was actually condoned. The issue was there was some other equipments.
So they say that when you submitted, there was an inspection being carried out in the year 2015.
Correct.
You did not show. You showed this 2,000 horsepower engine out here for this.
2,000 horsepower engine. The third party, well, I don't have any control. Third party inspectors are from their panel. Number one. Third party inspectors inspected it at the Dimahasau site so far as the engine is concerned. That is why, my lord, page 62, Lordship will find Oil India stroke, my lord, my site.
That I understand.
So,
the allegation appears as I see of 56.
Yes.
As per the TPI report dated 24/7/2023, submitted by you against tender number. This is the Dimahasau tender.
This is against this tender.
Okay, tender number so and so against which the subject contract was awarded. The aforesaid equipment was physically inspected by TPI agency on so and so at location. This is not Dimahasau.
No, my lord, this is what I am on, my lord. The third party inspection report, my lord, Lordship will see page 60. My lord, in the main inspection site, they mention only my site because, my lord, the bulk of the equipment is there. And one of the parts, which is the engine part, that was inspected by them at Dimahasau. That's why at page 62, they mention also at Oil India, because Oil India, my lord, doesn't have, my lord, any site where the rig was located. Patua Moran is my godown.
No, tell me whether in the year 2023, July 2023, the third week, when the inspection was carried out, where was this particular machine?
It was at Dimahasau, at the site of Oil India.
But why, while physically inspected by TPI agency on Iman, it was at Tornado?
No. Well, this is what I am on. The entire rig was at my godown at Batua Moran. So, my lord, the main place of inspection at page 60, Lordship will find they mentioned Batua Moran. But my lord, at page 62, they have also mentioned Oil India and that. I have disclosed, my lord, there is, and the photographs itself, which is also there, my lord, it is at the Dimahasau site. But because, my lord, the third party inspector mentions it as, my lord, Batu Amoran, because that is where the bulk of the rig was there. The main rig was inspected over there. They mention it as that the primary site. But at page 60,
So you mean to say that the inspection report was wrong?
inspection report was not wrong. Inspection report also mentions at Oil India site, page 62, Lordship will find.
Understood, but the simplex side, oblique simplex.
No, my lord, Oil India oblique Batu Amoran. Kindly see page
No, no.
62.
Page 62, oblique, there is no Batu Amura and all. Here it says Oil India.
Oil India stroke simplex site. So simplex site is Batu Amoran.
At that point of time, Mr. Counsel, your client was working out there at Dimahasau.
Yes.
So it was there, but this inspection was carried out where? At Torado.
My lord, this inspection, the main rig was there at my godown at Batu Amoran. The main rig.
Mr. Counsel, I am not concerned with this Batu Amara. Tell me as per the district where I. Dimahasau is a district.
Yes.
Torado is a different district. Now the question which is there in the allegation, don't come up with other aspects. The allegation out here is that in Soraido, it was found out that this particular machine was there as on the inspection carried out on 3/7.
On 3/7, it was.
Was it there on 3/7/2023 at Soraido or not? My principal.
On 3/7/23, my lord, it was there at Dimahasau and it was
So
inspected.
therefore, the inspection report was wrong insofar as that machine is concerned.
No, my lord, the inspectors also inspected it their site.
Understood, but it could not have been when you are saying that it is in Dimahasau.
My lord, the inspection was only of the engine. My lord, I just bears with me for 1 minute. My lord, the third party inspectors, they come, my lord, they inspect the main rig at my site, and since, my lord, this engine was, my lord, opened from there and it was my lord being utilized at the Dimahasau site. They also visit the Dimahasau site of the Oil India, and Oil India is aware of that. Only for the engine. My lord, it's a 2000 horsepower engine, an idle rig. I have removed it and I am using it in a contract which is currently subsisting, because at that point of time I had only one contract.
So the inspection which was carried out at Torado
In fact, my lord,
was of a machine without the heart. Something like that, because it didn't
no,
have the
the inspection at Batu Amoran was, my lord, Lordship is right.
Okay, now let us go further.
Now, my lord,
You were issued the notice, then what happened?
my lord, then, my lord, I answered, and then the termination comes. Lordship will come to the termination notice
Yeah.
of 9th June 2025. My lord, before that, may I show your Lordship, my lord, our response?
So they are therefore saying
Yes.
that you never had the intention of doing it.
Yes.
Kindly come to paragraph 4, page 77.
Yes, my lord, I am on there.
However, in your offer
Against the respective tender, you have submitted undertaking confirming categorically to complete the mobilization within 120 days from the date of issuance of mobilization notice, and also mentioned that your rig is free for deployment at the shortest possible time. Moreover, in your offer, you have not mentioned that your commitment of these equipment under OIL's contract number 6117405. But their my lord, main issue or allegation is that if you would have adhered to the original period of the contract, hold on.
So you have been terminated.
Yes.
Now you have been asked to vacate.
Terminated, vacate, and my lord, in the reply I have been given another notice has been issued asking that whether you have any 2000 horsepower rig. I have again given my offer, my lord, that is under consideration. So, my lord, that is my lord, so the idea is only to, my lord, forfeit my security deposit here. My lord, the main allegation, my lord, I am quite aware of, my lord, what is falling from your lordship, that arbitration clause is there. I go to arbitration, whether I can seek specific performance or damages is a remedy. My lord, I am not on that at all. Either I succeed on an arbitrary action or I do not. Now, my lord, my limited case is of an arbitrary action because your entire show cause was on the ground of mobilization. And once,
Mr. Katia, you were appearing in another matter, which is that matter, which is
Theros,
when,
Theros.
what is that? Same client.
No, this is different.
In fact, what has happened with the council, the thing is like this, the council who moved this petition, as well as the council who moved that petition, I said that there was an arbitration clause in that. But here I understand what is your case. Here your case is, look here, you have already condoned my case.
correct.
You have allowed me to mobilize on 26/5/2025.
With LD.
And accordingly, I have mobilized. Now, after having mobilized, you have, when you have already condoned, where is the question of now taking up an issue? That what I said, I have not given proper reasons for.
Correct.
This is your
This
case.
is my case. And my lord, another thing I must indicate to your lordship also, lord, all along, my lord, the fact that it is, and Dima Hasao contract is complete. There is, my lord, what they are trying to say is, my lord, I indicate what is their real grievance. Their real grievance is that to suggest as if the delay of 1 year was that I would not have been in a position to
Mr.
give.
Counsel, I think
Yes, yes.
I have understood that.
Right.
You were, their case is that you were not in the activity of work because of your ongoing work in Dimaha. And you have misled us, and thereby you have caused a delay of 403 days. And now, later on, we come to know why you have delayed. And therefore, we find that you have misled us, so now we are reaching
Correct.
the
And my lord, now again, my lord, after the termination also I have again been invited. So it is not really, that is neither here nor there, but I am only trying to say that this is just my lord, to forfeit my security deposit. Because here also they have,
How
my lord,
much is your security?
well, I take instruction. It is quite a substantial amount, but lord, again,
But
if,
would it be more than the liquidated damage? Because they are doing it, you have taken.
my lord, I am quite conscious, my lord,
You
that
have accepted with liquidated.
yes. My lord, I am not altering my position there. I am quite aware.
The liquidated damages is the question out there, which
Yes.
far exceed the security deposit. Then how do you take care of?
Well, liquidated damages will be as per the contract and they have put me on notice. I have accepted that still I want to do it. And after mobilization,
What would be the liquidated damages?
well, that, my lord, they would be able to say, my lord.
It is always there in the contract, if there is a date, but date, I don't
Yes,
think.
my lord, liquidated, I'll give you a lordship.
I think this will be a case coming on.
It is a certain percentage of the contract value.
It is a case coming under 74, not 73.
Correct. 74, if their loss is, my lord, more than that, that is the ceiling. Less than that, my lord, lordships are aware.
My learned senior friend on 2 occasions submitted that the Dimahasa work was over in September 2024. That in fact is also an incorrect statement before this honor. Actually, the work ended on 18th of May this year. Just 7 days ahead of the last date of mobilization. So here also,
But Mr.
Lordship,
I'm not on the other. Here the question is, so it has been said many things. When you have condoned till 26, for whatever reason,
yes, Lordship.
they have misled you to condone,
Yes.
for which you have condoned. But after having condoned, after having them mobilized, now would it be fair on the part of you? Then look here, we have condoned it wrongly, and we should not have condoned. Means, are you not reviewing your?
No, the issue is that condonation they have misrepresented before us.
Understood, I understood.
So if
Everything-
we allow this kind of misrepresentation,
But
in-
Mr. Tekya, where these are both sides under what it.
these are both
You
sides.
knew about this thing.
The
very well.
here, if we have to see their undertaking, page number किमान ito? See,
So for that, you are already imposing liquidated damages.
no, he has given an undertaking that within 120 days, that undertaking was given in
In
sometime.
spite of undertaking being given, Mr. Tekya, in spite of undertaking, why on earth did you extend that by giving him
No, we, rightly or wrongly, we have given it. That is not the issue.
No, no.
The issue is that,
Even the right.
Suppose-
Only, now later on you
No.
realize, hey, this person has.
Yes,
taken us
paid with
for a
us.
right.
because a lot of things, mostly commercial, are based on fate. And if that fate is lost, is there no remedy or no action we can take? Under the contracts clause 41 is there?
You are imposing liquidated
No, no.
damages.
No, we are not on that. Liquidated damages from other. And one more thing, it is not only the machines, two other important machine parts, components.
But
It
that is not your so-called.
That is a so cost. It
No,
is
no,
there.
Your so-called categorically say that we say that look here, this contract was there.
Yes, in the so cost, it is there, Lordship. All the facts are not placed. That's why.
I have read 56.
Yes, page 56. The rig engines, the mud pumps, and the compressor.
Yes.
Three components are not there.
No, it's okay. No, here you see, not the reprinted. We would like to submit as under. Rig engine in this connection, following rig equipment, we'd like to submit. These are it. As per the report of yours submitted by your so-and-so against the subject concern, the aforementioned equipment was physically inspected by the DNSA on so-and-so. However, it is seen that the equipment mentioned above were actually operating under the contract number so-and-so in Dimasao during that particular period. Thus, the information provided by you in the TPI record submitted by so-and-so does not align with the actual practice status of the rig venture.
At the time of
Considering the above fact, and development oil is now of the considered opinion not to allow you to commence operation, and according to the completion of the mobilization of your rig is kept in abeyance still further notice.
Lordship.
In view of the above, you are advised to clarify your stand on the above discrepancy of committing the same equipment against one tender when the equipment is under the obligation in another contract, which appears to be a wrong and a false declaration. You are now requested to submit your reply to the inconsistency of the present same equipment at two different locations during the same period by 2/6 year. Otherwise, we'll be constrained to take appropriate as per the terms and conditions.
Yes. Now let us go into the terms and conditions. One thing is very clear that there is misrepresentation. And when a rig is given to a particular party to operate, our officers don't go every day to inspect which machines they are using or which equipments they are using. That is not our job. We want the outcome. So whatever they are utilizing, it is to their knowledge. My party or my officers cannot go and inspect day in and day out. So what they are doing, they are using the three major equipments in Dimahasao by giving undertaking that we are going to complete it within 120 days. Suppose they have given that
They will
commitment
mobilize within 1 week.
120 days. That means that was given in 2023. The contract in Dimahasao ended, the work was over on 8th of May 2025. So that when they had given that undertaking page 360 of our affidavit, Lordship will kindly listen.
Mr. Secretary, let me come back.
Lordship is taking this matter.
You kindly take the information two things. One is how much is the liquidated damage as per the contract?
But it's 7.5%, which will come to around 16 crores to the maximum in this contract. And security deposit over there is around 5 crores and odd.
That is the liquidated damage.
For this, the security deposit which is liable to be forfeited is 5 crores and odd. And my lord, this contract, if they impose liquidated damages, maximum, my lord, as it fell from your lordship under the Contract Act is 7.5% of the contract value, which will be around 16.5.
Yes, page 37.
57.
Yes, of the writ petition. 41.0. Commission of misconduct, submission of fraudulent documents by the bidder, contractor, and banning thereof. The information and documents furnished by the bidder, contractor in respect of tender, contract are accepted by the company to be true and genuine. However, if it comes to the notice of the company anytime, either during the pendency of the tender or after award of the contract or after completion of the contract, that a bidder contractor furnish fraudulent documents, false
You're
info-
reading which provision?
Clause 41 at down below, Lord. May I repeat again? The information and documents furnished by the bidder contractor in respect of the tender contract are accepted by company to be true and genuine. However, if it comes to the notice of the company anytime either during the pendency of the tender or after award of the contract or after completion of the contract, that a bidder contractor furnish fraudulent documents, false information in relation to the subject tender, contract, or committed any misconduct, appropriate action shall be taken against the bidder contractor for debarment, banning of the bidder contractor from participating in any future tender of the company in terms of the company's banning policy, besides making the contractor liable for other penal actions, including termination of ongoing contract at his risk and peril. In such events, performance security in respect of the ongoing contract shall be forfeited by the company. So it is basically a fact-finding exercise which Lordship is now doing. Whether there was actually misrepresentation or not, that can be taken by the next clause, clause 42.1, that arbitration clause. They are giving a completely different picture, which actually is different from our findings. Our affidavit also clarifies a lot of things. So when he had said that he will complete the work, the mobilization, page 362 of our affidavit.
What is the date of this report which is given at page 50?
20. Just 1 second.
24th July 2023.
And this is at the Dimahasa outside? No. This is at,
That was very interesting, Lord.
this is at what side?
Well, at the both, the rig is at, well, at Batu Amo Road, and well, at the HP, the engine was inspected at the Dimaha South.
60.
That is why, my lord, what they should have done, my lord, at page 60 itself, they should have mentioned it at both. But my lord, they are third-party inspectors of Oil India.
So you submitted this document?
Along with the bid. Along with my bid. And my lord, only after my technical bid is accepted, my lord, they call for the price bid.
Lordship will kindly come to page 63, clause number 3. Although my learned friend is saying it is for both the sites, the site actually which was to be inspected by this team is regarding the current location at Soraideo, not Dimahasao. And at that point of time, the mobilization was not completed here. And both are different, totally different contracts, Lordship. Nothing to do with each other. Serial number 3, current location. The rig is in idle condition with base office address simplex so and so. Here,
What is this? Review, found satisfactory, review and test certificate and document and attach its one. Physical verification and ER check model to and all equipment pairs subject to undergo regular and preventive maintenance as per manufacturer. Performance and operation has been found ideal without operation. To the inspection of the notification as per email. So this inspection as per tender. Equipment requirement as per tender made in This report does not show that that particular machine was not there. The engine was not there, it is not shown.
No, because the engine was inspected. My lord, I just explained, my lord, give me just 2 minutes. My lord, at Dimahasau site, my lord, and my learned friend will not disagree, the engine requirement at Dimahasau site was 1,500 horsepower, not 2,000. But because, my lord, this rig of mine was lying idle, when there was a problem in that engine, and my lord, repairing it and obtaining spare was an issue, instead of wasting time, we offered them the 2,000 horsepower engine and we put it over there. And that is recorded in a letter of 17th March. Then, my lord, they in their opposition, they have relied. They are saying that, my lord, and we had also given an undertaking that we will complete the contract and it will be for your use. But, my lord, the main engine was repaired thereafter, but we did not replace it again because my 2,000 horsepower engine was lying.
My question is, on 2nd, 3rd and 4th of July, when the inspection was conducted,
Yes.
the rig was inspected without the engine.
Yes. The rig was inspected at my site, which did not have the
No,
engine.
no, so the inspection report is without the engine.
No, the engine was also inspected at Dimahasau.
No, no, here it doesn't say so, sir. It says so, huh?
Well, at page
Kindly see.
62, my lord,
No, you see, kindly come to page 61.
yes,
Performance and operational check as rig found ideal without operation. Okay, then you come to next page. Reference to the inspection notification per email dated so-and-so inspection carried out dated 2nd, 3rd, 4th July 2023 as per Oil India Limited and per scope of work given by Simplex so-and-so physical verification documents found satisfactory. Subjected to MS Simplex to provide declaration or assurance that the equipment requirement as per the tender document will make in operation and intact with overhauling for smooth operation as rig found ideal, not in operation from last 3-4 years. However, unable to conduct no load operational check due to unavailability of required sources at the site and idealness of the equipment. Overall equipment found fit for operation, new rig purchased on so-and-so, on subject to undergo regular and preventive machines as per the manufacturer. Inspection details so-and-so items verified and tested. Certificate reviewed at Oil India Limited Simplex site. Now Simplex site, Assam would be here. We have been given a Simplex site. Inspection is at Batua Moran, Assam.
yes.
That is the inspection site.
And Oil India site is at Dimahasau. And my lord, Lordship will note one thing, my lord. Rig found ideal but not in operation for the last 3 or 4 years. It was lying there. And my lord, that is why, my lord,
So that means this inspection report did not look into the machine or the engine.
engine was also, my lord, the pictures are there. My lord, the third party inspectors had gone to the Dimahasau site, taken pictures, but my lord, they only mentioned that. For that, I can't be at fault. And this was submitted along with the bid. Lordship will find the pictures.
What is the page 63 and 64?
The location of inspection is given as Saraidao, Batuamala.
No, page 63. What is this?
63, yes, after serial number 3, current location of the rig. Lordship will see. The rig is in ideal condition with base office at Simplex so-and-so in Guwahati, Dibrugarh. Current location LOC MFFI, village Batua, Dipling, Soraideo.
So it is in Soraito.
It is in Saraito.
So now kindly come to the next page.
Well, it
Kindly come to 6.3.
Yes,
yes, madam.
these are the machines.
Engine number so and so,
Absolutely.
Mitsubishi so and so, yes, May 2007 years, refer to remark. So therefore, they have looked into the engine.
Well, yes, they have, and they have taken photographs, page 74.
So,
74 and 75 are the photographs, but Millard, only thing what they should have mentioned is these engines are presently over there. And Oil India is aware of that. Because, my lord, these engines, my lord, I can understand the case made out by my learned friend, my lord, is perfectly valid. My lord, had it been that the other contract required a 2000 horsepower engine, and I am, my lord, showing the same engine for two
At page
contracts.
74, which is the engine?
My lord, kindly see mud pump unit towards the middle, mud pump unit with mud tank, and my lord, diesel generator set at the bottom, cold start compressor. These are all at the, my lord, Dimahasau side. But my lord, I agree. My learned friend is right. My lord, the third party inspectors should have mentioned it instead of only saying at page 62 Oil India site. Because my lord, at that point of time, I had only single Oil India contract. So Simplex site and Oil India site. Page 62, both the sites are mentioned. But my lord, if another line would have been added, it would have perhaps, my lord, it would been more clear. But my lord, that doesn't mean I have suppressed anything. And my lord, the second most important point is the Dimahasau site did not require this engine. It's a much higher capacity engine which I out of my own volition had given because the other rig was lying idle. I said I have an engine there. 17th March I have written that letter. Now, my lord, they in their opposition, they are themselves relying on a 1st June letter and they are saying, no, you had.
Kindly see.
Yes, my lord.
Page 74.
Page 74.
234 July at Simplex, Patuamoran, Assam. Then why these photographs have been mentioned as there?
It should have, page 62 they have clarified, but my lord, the site of.
Only they have put the Oil India site, that means you have clarified, but all other documents show that these are there.
My lord, I can, my lord, what is the allegation? The allegation is I have made a false statement. But I have not made any false statement because, my lord, Oil India is aware and I am working with Oil India since 2008. I have only with Oil India. I don't work with anybody else. I have, my lord, 2 rigs. One is of with 2000 horsepower, another is with 1500. My lord, when I was operating, my lord, kindly have a look at the 17th March letter once, my lord. 76. Page 76 once. My lord, I can understand my learned friend's contention that, my lord, I have the other contract required this engine. I have one engine and I am, my lord, showing the same engine for 2 contracts. Absolutely right, my lord. Lordship would have thrown me out of the court. This is on 17th March 23 with reference to the observation made by oil inspection mentioned in the attached differ from what we have quoted in the bid. We accept the fact and mention various factors under which we replace this item with better model so as operations in the remote Dimahasau will be carried out more smoothly. Please refer attached file for item wise ones. And my lord, Lordship can take it from me and my learned friend will also not dispute. Dimahasau contract requirement was 1500 HP. And my lord, that other engine was replaced. Now, my lord, in their opposition, now Lordship will see, my lord, they rely on a 1st June letter.
Where?
My lord, 357. ওই চিঠিটা যেটা ওরা রিলাই করছে comparative.
357, no.
I'm sorry, my lord, it is 394. I'm sorry, 394. 397. Their letter. Give me their letter. Yes, my lord, 397. This is the letter they are relying, 3rd May, 397. I'm sorry. My lord, kindly see the reference, my lord, at the top. hiring of 1400 HP rig package for 2 years. And this is what, my lord, I had given. Offered model was this, it was a higher equipment and, my lord, it was under, kindly see the reason for replacement. It was under overhauling and due to non-availability of replacement spares of time, it could not be mobilized with the rig package. We have, however, provided better conditioned equipment. In view of the remote site location, we confirm this equipment shall be available for the entire period of the contract and extension if any. But equipment will be available. That doesn't mean the higher machine, which was a temporary part, my lord, they are trying to construe that because I had written this letter, for all material times, I am to keep it
So
with.
this is a document which you have submitted for the Dimahasa project.
Yes,
So you say that these equipment which you are going to provide shall be available for the entire period of the contract and extension if any.
yes, equipment means what, my lord? The top, right at the top, my lord, what you will see, hiring of 1400 HP. The equipment is different. It's the other rig. $1,400 HP, my lord, I am obliged to provide. I provide, my lord, the reason for replacement, kindly have a look at that. So, my lord, if the repairing takes 1 month, it will be there. If the repairing takes 6 months, it will be there. The equipment will be functional for the entire duration. And, my lord, they don't dispute that. But that doesn't mean I have to keep that 2000 HP over there and I cannot participate in other contract. What will I do when, and 1400 had come back? But because I did not have any other contract, I, my lord, made the bid and that was ready. If I would have opened that and taken it, 1400 would have replaced.
Wait. This 3/5/2023 document.
Yes,
So you offered these machine which is there
yes,
at the genset 1. Offered machine is of 1500 RPM, 1143 kilowatt. Now the replaced machine which we are going to give is that serial number, all these things.
and this serial number is identical to what we had bidded and what was inspected.
Yes. Now this is what you say. Now if you say that this machine will be kept out there throughout the entire contract period, then how did you do it when you have done it in the month of July?
My lord, maybe, my lord, I am not clear. My lord, kindly see, my lord, the next column after that. Residual life of replace, reason for replacement. Well, kindly see that first.
Now, understood.
Yes.
But see the remark.
Yes, we have provided better condition, lower vintage period equipment in view of remote well site or location, because, my lord, that point of time.
It's okay. Then
Yes, also we confirm have this equipment shall be available for the entire period of the contract and extension if any.
so during this period, your inspection was carried out in the month of July 2023 in what you
Correct,
mean.
correct.
Now, this contract where you were to mobilize with 120 days as per your undertaking. So this contract, as per you, let us take it as per you, in September 2024 you completed.
Yes,
So this machine was there till then.
yes, because I
So,
did.
so you couldn't have removed in view of the
no, no.
undertaking given at 397.
But this is where, my lord, I am joining issue so far as the undertaking is concerned. Undertaking is what? Undertaking is, my lord, because it's a remote site, and, my lord, there would be difficulty in, my lord, getting a replacement spares readily. My lord, undertaking is it will continue to be at site till this equipment means the entire, you will have 1400 horsepower and above at the site for the entire period. That is the undertaking. Allow me to give a better power now till such time the equipment comes.
No, that is not your undertaking. Your undertaking out here that this machine, the substituted machine shall remain till the contract is over or even if
But
the extension
I
is
shall,
given.
but this is now being construed after this has
I'm
been
not
done.
construing it. I have not heard them on this, but the moment
Well,
you say,
Lordship
and
is-
also we confirm that this equipment shall be available for this entire period of the contract and the extension if any.
Correct.
I'm not even gone into what Mr. D. Sekia has submitted to the effect
But
that he completed in the month of May 2025. I'm not even on that. But if assuming that you, as per you, what you are saying that it is completed in the month of September 2024, that means within that 120 days, you were not in a position to give it because of this undertaking which you have given.
No, my lord, I'll indicate, my lord, it is this, my lord.
Now, Mr. Counsel, what do you want? A dismissal right away or go to arbitration?
No, no, my lord, arbitration, any event, my lord, that is always open, my lord. My lord, if lordship will just bear with me for 1 minute.
No, no, no enough.
1 minute, my lord.
Your name now.
My lord, I am Shoboshachi Chaudhary.
The learned counsel.
My lord, one mail lordship, one document lordship sees and thereafter passes
No,
on.
no.
My lord, they have asked us to again give that offer.
That offer is
Only
for
thing
some
is,
other.
if you go for arbitration, I stop myself from making that comment on 41, which I don't want to move. It may affect. That is only the reason why. If you want to go for arbitration, it is better. Because I may have to say, because these things were not there, which may affect you in an arbitration proceeding. That's the reason.
No, my lord, if lordship, my lordship gives me.
Otherwise, yeah, because on the face of it, this particular document, because I've seen that inspection report, the inspection report also seems to be it doesn't seem to be proper, because how on earth they could have said that this is a photograph of that particular area? This
My lord,
particular document.
with regard to inspection report, my lord, I have no manner of control.
No, you have no control, but this was the basis on which you got.
But my lord, lordship is absolutely right. My lord, the mistake that I had done was, my lord, I had replaced a higher quality machine there. And my lord, this language of the letter is being construed that 2000 HP will be there for all times to come. Though, my lord, the contractual requirement is 1400. Because the reason is, my lord, there was a spare part unavailability. But my lord, that was replaced with
The
it.
council, which one do you want? I give an offer.
The lordship just gives me a minute. Thank you.
Let me first start the formality.
Yes, my lord.
And I can do it by the time you get there.
No, no, no.
That's
You
when
can't-
the
you can't withhold the
senior
vote.
council is hearing on behalf of. Yeah, it's back.
No coming back.
You take the inspection hearing. Mr. D. Kaita, the learned senior council. It's by Mr. Peter. And you're there. And Mr. K. Kolita, you're the behalf of respond on. The petitioner herein has approached this court challenging the termination of the contract hearing number 6119345 oblique CDG 3526 P24 oblique DRLG oblique 24. By the termination notice dated 9/6/2025. As well as the subsequent communication dated 18/6/2025, whereby the petitioner has been asked to vacate the drilling site with immediate effect. The case of the petitioner herein is that an e-tender hearing number CDG 3526 P24 dated 23/5/2023 was floated inviting competent and experienced contractors for charter hire of 5 numbers of 2000 HP bracket minimum drilling rig packages. The petitioner participated in the said tender process. And a letter of award dated 12/3/2024 was issued in favor of the petitioner for charter of one number of 2000 HM drilling rig package at a total estimated contract value of 222,52,44,000 for a duration of 4 years. The petitioner was also directed to furnish a performance security for an amount of rupees 4,96,41,000 in the form of Bangarin. The petitioner accepted the letter of award and furnished the cash security for a sum of rupees 4,96,71,000. It is pertinent to mention that in terms with clause 2 of the letter of award dated 12/3/2024, it was mentioned that the contract shall be effective from the date of issuance of the letter of award. Clause 3 of the letter of award relates to mobilization. The same clause have relevance to the present proceedings. And as such, the said clause is reproduced herein under page 29. From a perusal of the said clause, it revealed that the mobilization of the rig should be completed within 120 days from the letter of issue of mobilization notice. It was also mentioned that if the rig is in operation with oil, the rig shall be deployed within 60 days from the date of dehiring from the ongoing contract, or 120 days from the date of issuance of the letter of award, whichever is later. The materials on record, from the materials on record, it's apparent it is an admitted case that for 403 days from the date of issuance of the LOI, the petitioner could not mobilize the rig. Under such circumstances, on 5/5/2025, a termination notice was issued stating inter alia that the mobilization against the contract had not yet been completed even after 403 days from the date of issuance of the mobilization notice, that is lapse of more than 280 days from the scheduled mobilization completion date, that is 26/7/2024. It was further mentioned that if the petitioner would not mobilize the rig in question within 25/2025, the contract would automatically stand terminated with effect from 21/5/2025 without serving any further notice. And other punitive actions as mentioned in paragraph 5 of the notice dated 5/5/2025 would be taken against the petitioner. It was also mentioned that if immediate corrective measures were taken within 25/2025, the petitioner would be allowed to continue with the execution of the contract, but liquidated damages would be imposed against the delay in mobilization as per the contract terms. The petitioner, however, it is also the materials on record further would show that the petitioner could not mobilize within 25/2025. But on the same day, the petitioner requested to extend the period to 26/5/2025. The respondent company granted this extension to 26/5/2025. And it was observed that if the petitioner could not mobilize in all respects within 26/5/2025, the contract would stand terminated with effect from 27/5/2025 without any further notice as mentioned in the termination notice dated 5/5/2025. The petitioner's case is that on or before 26/5/2025, the petitioner mobilized its rig. However, on 26/5/2025, the petitioner was issued a letter seeking clarification the said letter in terms with the said communication dated letter no communication. In terms with the said communication dated 26/5/2025, the general manager contracts bracket of officiate and contract bracket officiate sought clarification from the petitioner in respect to pre-rig equipments. That is, number one, rig engine bearing serial number 16349, 16329 and 16324. Number two, mud pump bearing serial number RS14-013. Number three, compressor bearing serial number 37214030-412, 372140-90761 and 15014. The clarification so sought for was the said equipments as per the EPI report dated 24/3/2023, 24/7/2023, were physically inspected by the TPI agency at location MFF-1, Patua, Corridor. But it seems that the equipment mentioned, the said equipment, were actually operating under contract number 6117405 in Dimahasau during that particular period. It was therefore sought, the petitioner was therefore asked to clarify on the aspect of non-aligning of the information so provided in the TPI report submitted against tender number CPG 352-6P24. And the petitioner was asked to clarify as to why the TPI report submitted against tender number CPG 352-6P24 did not align with the actual practical status of the rig equipment at the time of submission of the bid and appears to be factually incorrect. The petitioner was granted time to submit the explanation by 2/6/2025. The petitioner submitted its explanation by the communication dated 1/6/2025, wherein it was mentioned that the three items mentioned in the communication dated 26/5/2025 were deployed out of the ideal oil rig at Batwa on or about 17th of March 2023 under due intimation to the Oil India Limited. It was further mentioned that this was done as per the existing terms at Dimahasau, as there was an urgent need for repair of the equipment, and there was a requirement for immediate replacement. It was further mentioned that in the said communication that the TPI report dated 24/7/2023 also indicated the said aspect of the matter. It was also mentioned that the three equipments only constituted 8% in value. And in any event, the three items forming the part of the drilling rig package at Batwamara have since been mobilized at DJS-Namruk within the extended time of 26/5/2025. The reply which was submitted by the petitioner was not accept the contents of the reply. The justifications were submitted by the petitioner by the reply dated 1/6/2025. was not accepted, and resultantly, resultantly, by the communication dated 12/6/2025, the contract in question was terminated by invoking clause 41 of the GCC on the alleged ground that the petitioner had committed misconduct of the submission of fraudulent document yeah, on 9/6/2025, on the alleged ground that the petitioner had committed misconduct had committed material breach of the contract and demonstrated a clear intent to mislead the respondent company. And accordingly, the contract with the petitioner was terminated. The petitioner approached the respondent company by submitting a representation on 12/6/2025. However, the same did not receive a favorable response. Consequently, it is also seen that on 18/6/2025, pursuant to the termination notice dated 9/6/2025, the petitioner was asked to vacate the drilling site. It is under such circumstances the present petition has been filed. The record further reveals that this court, by an order dated 26/5/2025, issued notice there was no interim order passed. Now I have to proceed.
My lord will pass my lord's order, my lord. I have taken instructions, my lord. The client will not go for arbitration. My lord, we will suffer, my lord, whatever. But you will not take me amiss, my lord.
No. I told you, because if I give an objection to that effect, observation it may impact. But anyway, I will take care of that.
Yes, yes. Because commercially, my lord, arbitration is not what, because either, my lord, we stand or we fall, we have to take our fate. But my lord, arbitration will not lead us anywhere. That is the conscious stand the client has taken.
It is seen from the records that an affidavit in opposition has been filed by the respondents numbers 1, 2, and 3 on 31st of July 2025. In the said affidavit in opposition, a preliminary objection has been taken as regards the maintainability of the writ petition on the ground of the existence of an arbitration clause. That is clause 42 of the general conditions of the contract. Without prejudice to the preliminary objections which have been taken on the maintainability of the writ petition, in the affidavit in opposition, it was stated that the petitioner had misled the respondent company at the time of submission of the bid in as much as the equipments, the reference to which have been made in the communication dated 26/5/2025 were not available with the petitioner at that relevant point of time. And in that regard, further stated that the petitioner under no circumstances would have provided those equipments, taking into account the undertaking given by the petitioner before the respondent, before the Oil India Limited, Executive Director, Oil India Limited, by the communication dated 3/5/2023. It was further mentioned in the said affidavit in opposition that the contract work which the petitioner was carrying out at Dimahasau was completed only when
18/5/2025.
18/5/2025. And as such, in order to mislead the Oil India Limited, the respondent company, without intimating, and in order to mislead the oil respondent company, the petitioner have been delaying the mobilization of its rig. It was further mentioned that in view of the misleading, informations and the documents so furnished by the petitioner and the respondent company having accepted the same to be true and genuine, have awarded the contract to the petitioner. And later on, the same came into light when the inspection report so submitted by the TPI agency and was noticed when the inspection report submitted by the TPI agency did not align with the actual oblique practical status of the rig equipment at the time of submission of the bid. Under such circumstances, the respondent company was therefore justified in terminating the contract in terms with clause 641 of the general conditions of the contract. The record further reveals that pursuant to the affidavit in opposition, a reply has also been filed reiterating that a contract number 6117405 dated 24/2025 22 was completed on 4th of September 2024. And thereupon, the oil drilling rig package HP 2000 was readily available for deployment. It was also mentioned that the respondent Oil India Limited were aware that the said machines, the machines which have been referred to in the communication dated 26/5/2025 was deployed in another site of Oil India Limited. And as such, the question of misleading or not providing due information did not arise. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties. Mr. So-and-so, the learned counsel appearing on contention of the learned counsels for the parties. Mr. So-and-so, the learned senior counsel appearing on behalf of the petitioner submitted. That the incident repetition, the issue so involved in the incident repetition do not require any factual adjudication on the basis of the admitted facts. And as such, the question of relegating the petitioner to the process of arbitration is not ought not to be made. The learned senior counsel submitted that the issue involved is as to whether the action on the part of the respondent authorities is illegal and arbitrary, inasmuch as having condoned the having permitted the petitioner to mobilize its resources by 26/5/2025, thereby accepting all the drawbacks, thereby condoning what has happened. Subject to imposition of liquidated damages. The question of terminating the petitioner, the contract of the petitioner, on the ground that the machines, some parts of the rig were not available at that relevant point of time, would amount to reviewing its own decision. The learned counsel submitted that as the petitioner only engages in contracts pertaining to hire with the respondent company alone, the respondent company was well aware that the three equipments so mentioned in the communication dated 26/5/2025 were used temporarily as replacement equipments for the purpose of running the rig operation at Dimahasa. However, in spite of having due knowledge and the same being even clear from the reports so submitted by the TPI agency, the respondent authorities now, for best reasons known, for reasons best known, wants to terminate the said contract in order to forfeit the security deposit, the performance security. The learned counsel, senior counsel further submitted that, that the respondent company now again have invited the petitioner for the purpose of supply of the same equipment. And as such, the intention of the respondent authorities do not appear to be fair and reasonable when the intention being only for the purpose of forfeiting the security deposit, performance security. Anything else? Per contra, Mr. D. Saikia, the learned counsel appearing on behalf of the senior counsel appearing on behalf of the petitioner, the respondent, submitted that the present case is not a case of condoning the lapses on the part of the petitioner and thereby taking action against them. The learned senior counsel submitted that this is a case whereby the petitioner had submitted the tender documents and indicated that the rig can be mobilized within a period of 120 days from the date of the mobilization notice. However, the rig under no circumstances could have been mobilized within 120 days. Inasmuch as the three equipments so mentioned in the communication dated 26/5/2025 could not have been deployed back in the contract site inasmuch as an undertaking has been given by the petitioner to the Oil India Limited that the said equipments would be kept where is that page again?
397.
The said equipments shall be available for the entire period of the contract and the extension, if any. First, he therefore submitted that even after the completion of the mobilization period of 120 days, the petitioner could not have brought those machineries in view of the undertaking so given. Inasmuch as, even assuming that the petitioner is correct, that the said contract was completed in the month of September 2024, the mobilization period of 120 days is over. The learned senior counsel further submitted that as per the instructions of Oil India Limited of the respondent company, the contract at Timahasa was only completed on, what is the date?
18th May.
18 May 2025.
Lord.
And the petitioner, though in the affidavit in reply had submitted that it was completed in the month of September 24, but there is no documents produced in support thereof. The learned counsel further submitted that the petitioner very well knew that it could not mobilize the rig till the completion of their contract with the at Dimahasa, and instead provided information that they were taking steps for mobilization of the rig. The learned counsel further drawing the attention of this court to the inspection report which was submitted by the TPI. Drew the attention of this court to the photographs enclosed to the inspection report, wherein it has been categorically mentioned that the inspection, the photographs were of 2nd, 3rd, and 4th July 2023 at MFF1 Batua Moron, Assam. And the three equipments so mentioned in the communication dated 26/5/2025 was shown in those photographs. And if that is not a misleading information, in order to take a contract from the respondent authorities, and that amounts to a misleading information so given to the petitioner, to the respondent company. And as such, clause 41 of the GCC is squarely involved. The learned counsel further submitted that in terms with section clause 21, the respondents duly have the power, is conferred with the authority to not only terminate the contract, but also blacklist the petitioner and forfeit the performance security. Anything more?
Arbitration clause, clause 42. If there is any disputed facts, then that is the option.
You are helping me.
And, the thing is that they are disputing the date of completion. Either way, Lordship, the thing is that even if it is considered as September 2024 also,
That I said.
yes, that our Lordship has already said.
Without you saying, I put it there.
And regarding that, whether those equipments were lying in Soraideo district or in Dimahasao. Regarding
That
the
also
report.
you
Yes,
said, na?
yes.
From the photographs,
Yes.
it is being shown that it is lying in
Dimahasa.
Soraido. No.
And that report says Assam. So
No, no, in
very,
Soraido, it was showing as Soraido. No, no. Here you can see the photograph. I said without you saying, na? Page 74.
the photographs were of Dima Hasa.
No, it says at Moran, Soraido. On top.
Yes,
Well,
Bakwa
that
Moran.
is exactly what I am saying. They also know the photographs are of Dima Hasao, but Lordship is right, my lord. The TPI has written it as Sarai.
So if
That's
this-
why, my lord, I had no role to play in that. And that is why in
I knew it, but this is a question of fact.
this
I
is
know
a
that,
question
I know
of-
that.
That's why my arbitration clause I'm trying to say.
No, that I said, no.
Yes, Lord.
Well, leave me something
And-
if I say both
and
of
that
you.
Clause
What is
3
left?
says, this is of Assam Oil India. Very trickily that report has been drafted.
Your third party.
That is your third party or my third party, that is not the issue. There is a
Okay.
panel and you have chosen it.
Mr.
Anyway, Lordship, if that is creating any issue, then that
No,
may be
no,
dropped.
no.
But in our affidavit, we have taken a categorical stand.
I've said, no.
Yes,
I've said in your affidavit.
because if it goes to the appeal, then this will be another ground for me. That's why. If the other side,
No, you have, I mentioned that in your affidavit you have said that.
we have said.
The learned senior counsel for the respondent further submits that the materials on record would show that the petitioner herein had provided information, had provided misleading information, which is apparent from the materials on record. And as such, the question of interference by this court under Article 2 to 6 of the Constitution does not arise. More so, do not arise. Because even otherwise, if there is any dispute, the dispute can only be resolved by way of an arbitration, as the parties have duly agreed to abide by the arbitration clause. Analysis and determination. The materials on record clearly show that the petitioner herein was awarded the contract of supplying one rig, of supplying one of hiring, of charter hire of one rig, one 2000 HP minimum drilling rig. And the letter of intent, letter of award, was accordingly issued on Twelve 2024. In terms of the mobilization clause as quoted here in above, the mobilization clause in the letter of award, which has already been quoted here in above, the petitioner was required to deploy the same within 100 days, 120 days from the date of issue of the letter of award. Or in other words, on or before 26/7/2024. Admittedly, the petitioner did not was not in a position, did not carry out the mobilization, which had resulted in issuance of a termination notice dated 5/5/2025, thereby asking the petitioner to mobilize on or before 25/2025, or else the contract in question would be terminated with effect from 21/5/2025. Petitioner thereupon was granted an extension up till 26/5/2025 on the basis of on request being made by the petitioner. The petitioner, the materials on record further suggest that on or before 26/5/2025, the petitioner was able to mobilize the rig. However, on 26/5/2025, the petitioner was asked not to proceed further on the ground that the information so provided in the TPI report did not align with the actual and practical status of the rig equipment and the submission of the bid, and appears to be factually incorrect. This court further finds it pertinent to take note of the communication dated 3/5/2023, which is of relevance, taking into account is of relevance. The same communication is a communication issued by the petitioner to the respondent company in respect to the contract being executed by the petitioner at Dimaha South. From the same communication, it is seen that the three equipments which have been mentioned in the communication dated 26/5/2025 were being offered as replacement with an undertaking which is being relevant is reproduced herein under inverted comma. We have provided the better conditioned, lower vintage period equipment in view of remote well site location, Also, we confirm that this equipment shall be available for the entire period of the contract and extension, if any, inverted comma, close. From the same document and the undertaking so given, it is apparent that the petitioner herein could not have removed these equipments till the completion of the contract of drilling it at Dimahasa. The petitioner had submitted that the contract in question at Dimahasa was completed in the month of September 2024, which have been denied by the respondent company. Inasmuch as per the respondent company, it was completed on 18th May 2025. 25. Be it as it may, the petitioner could not have used these free equipments as per their own undertaking given on 3/5/2023. Even assuming that the statement that the petitioner had completed the work at Dimahasa on Dimahasa in the month of September 2024.
One vital fact.
Inasmuch as yes, what do you say?
This present tender at Saraideo, it was floated on 23rd May 2023. After 20 days of this later.
Be that as it may, it is very pertinent to observe that even assuming, for argument's sake, even assuming that the petitioner had completed the work at Dimahasa in the month of September 2024, the petitioner could not have used these three equipments which have been mentioned in the communication with the 26/5/2025 till September 2024, which was well beyond the period of the mobilization period, which was well beyond the mobilization period. The materials on record further do not show that the petitioner had indicated that the rig, drilling rig which the petitioner had submitted, had offered in respect to the notice inviting the e-tender dated 24/3/2023.
23/5/2023.
Is also not indicated in their offer, which was submitted on
8th August 23, we had submitted our petition, Lordship.
8th August.
8th August.
On 8th August 2023, that the drilling rig which have been offered in pursuance to the contract notice inviting e-tender dated 24/5/2023, 23/5/2023, did not contain could not be used, would not contain these three equipments, which are essential to form the drilling rig. On the other hand, the petitioner have relied upon the TPI report, which gives a vague and an ambiguous report, which prima facie gives a vague and an ambiguous report. In respect to the machineries, in respect to the in respect to the drilling rig, which has been offered by the petitioner. In this aspect of the matter would be apparent from the fact that in the photographs, which are part of the report so submitted by the TPI agency, taken on 2nd, 3rd, and 4th of July 2023, it has been shown that the three equipments, that the photographs have been taken of the three equipments referred to in the communication dated 26/5/2025 at Batua Moran in the district of Soraido, Assam. Whereas at that relevant point of time, the said machinery, the said equipments have already been offered to the Oil India site at Dimahasau. The petitioner also, further to that, from the pay report, it appears that it also prima facie appears that the report have been given in such a manner that the drilling machine, the drilling rig, have been inspected as in a composite manner. But a line has been inserted in the said report that the item, inverted comma, that is, items physically verified and test certificate reviewed at MS Oil India / MS Simplex site Assam, inverted comma, close, page 62. Therefore, apparently, therefore, the decisions were taken by the respondent authorities to exercise the powers under clause 41 within the limited, if looked into within the limited scope of the jurisdiction of the court, do not appear to be unreasonable and arbitrary. To exercise the powers of judicial review. Consequently, this court do not find any merit in the present proceedings. Consequently, the incident with petition stands disposed of with the following observations and direction. This court, from the materials on record, do not find the present case to be a fit case for exercising the power of judicial review. Number two, the observation. This court further takes note of clause 42 of the general conditions of the contract, which stipulates an arbitration clause. The petitioner, if so aggrieved, would be at liberty to approach, would be at liberty to invoke the arbitration clause. It is observed in 3. It is observed that if the petitioner invokes the arbitration clause, seeking resolution of the dispute, the observations so made herein above in respect to the actions on the as regards the actions and the observations so made in the instant judgment shall not affect or prejudice the petitioner. I kept both of it.
My lord, irrespective of the outcome, my lord, it was a pleasure appearing before your lordship. My lord, lordship.
We have taken the time of it. Yes, very.
Being at one.
I took
Deeply obliged.
yes. Oh, you, where's the other one?
But I'm told they are not agreeable to the mediation. I'm told.
Why?
Subject to correction, my lord.
Where is
They should have-
Mr. Doctor?
Mr. Wataka was there. He's just outside perhaps. Yes, he's there. But I believe that one fair chance.
Yes, Mr. Borsako. Why didn't you go to mediate?
Lordship, I have taken instruction from my client. They feel that mediation will fulfill no purpose. Still, your lordship, since your lordship has
No. Both of you have to agree. In fact, this is a case for mediation.
lordship.
You see, you have asked for some money in lieu of, you see, what otherwise you can get. If there is no retrenchment. The case which appears out here is this. You have submitted a voluntary resignation is what they say. And therefore the termination has happened. You say that they could not prove it. So it is a case of a the termination. It is a case of a retrenchment, but without following 25F. Your entitlement at best would be 1 month or 2 months of salary, whatever may be, or some notice to the effect. So at the end of the day, if you will reach a compromise, I think it is a better option how they tackle it. So let me send it to the mediation. Now everybody in all other courts, you find a lot of lists out there for sending it for mediation.
Lordship.
Let me be one of those without that list to go for.
Lordship. Only prayer that I would like to make your lordship before this honorable court, your lordship. If
2
your
months
lordship, in the meanwhile, if they pay your lordship that under what is, and we are entitled under section 17A, your lordship. Because your lordship, they are in very dire straits, your lordship. No money, nothing, your lordship, no work. That's the only, your lordship, prayer I would like to make, your lordship. Let it be in the, go to the mediation.
Let it go to a mediation
Lordship.
and ask the mediator to submit a report within 2 months.
But
Let it be done early.
it can be prior to that also because we'll wind up.
Because for me, this is a 5 minutes job. to
Lord.
finish it off.
Lord.
So, but what to do? Okay. It has been submitted at the bar that taking the dispute in question the parties may, whom would like to mediate, would like to go for mediation, which is another form of dispute resolution. Accordingly, this form refers the instant petition, this instant dispute, to mediation. To the mediation of the Guwahati High Court, Guwahati High Court Mediation Center. And request the mediator to submit a report within 2 months from the date the present proceedings are placed before the mediator. Just list this matter again on 28th of October 2025. Yeah? August, September, October.
Article 9 and 10.
What is that?
I pick another date, my lord. This, what is the interim order, my lord? This way, I think railway, my lord. There is interim order.
The Pinnacle obtained an interim order and then.
No, he is,
the
my
matter.
earlier council was different.
Huh?
Earlier council different.
Okay, 9 and 10, Tikati.
My lord, 4th of my lord, September, my lord.
Oh, better. Yes. What is that? Which item is fixed at 2? Mr. PP Doctor, what is this?
With this matter, the management has said the award of labor court whereby labor court directed to reinstate of the petition. On last,
Oh, non-appeals for the
Yes.
petitioner.
on last
Yes,
two
so.
occasions.
Anybody appeared
One Topon Roy appeared earlier.
today?
No,
You should, type to correct. I'll list the matter again on Tuesday.
that's it.
Okay. But mention it.
That's it.
I forget because so many matters. The other matter took a lot of time.